Good afternoon, everyone. It is Friday, February 19th. Welcome to Senate Education. Sometimes I feel like saying I'm your host, but this is Senate Education, where we are going to be returning to a couple of topics, but quick housekeeping, 2 weeks to cross over. So that means we have next week to vote out bills. Then we'll have our crossover break, and then we'll come back and we'll have another week. We can, if there's something we don't get out, you can always ask for an extension from the Rules Committee, work with the corner office, Senator Balance team. But at this point, I'm anticipating that we should be okay, but we'll see. So we are going to start by returning to the topic, the broad topic of church and state. Mr. Desmarais has a new draft for us. Then we're going to hear from Ledge Counsel and Bor Yang. Many of you know Bor through her work with the Human Rights Commission. And then senators asked the very good question around funding. Where are some of the funds going to be coming from when people are talking to their constituents and others, and just for broad knowledge? So I've asked Joint Fiscal to come in. Catherine Benham and Steve Klein will talk to us a little bit about, funds, dollar amounts, where possible funding may come from, as we give our recommendations to appropriations. Related to that, I did share with the Pro Tem and the Chair of Appropriations last evening a draft of our letter, and just generally letting them know the direction that we are heading in. One of the things Ms. Benham and others have reminded me of is that there will be multiple trains leaving the station going forward as it relates to appropriations. We know that there are, just to repeat, as we've talked about, budget adjustment, and then this expedited bill, we have the big bill, and also the possibility of other funds. And I know that Ms. Benham and Mr. Klein will give us additional information on that. We will then talk a little bit about Vermont's education professional standards. Senators may recall one of the things we've been interested in is streamlining standards for teachers with the hope that we might increase our pool of applicants, etc. One of the tools possibly in our toolkit. And then we'll wrap up the day with Secretary French. Appreciate him coming in to talk with us again about our letter. There are still a few holes, and see if we can help address some of those outstanding questions that we have. So with that, not seeing any hands up, I think we will go to Mr. Desmarais.
Okay. Good afternoon.
Good afternoon.
For the record, Jim Desmarais, Ledge Counsel. We are talking today about the ability of a school district to use public funds to pay tuition to a independent school with a religious mission. And before I go into the bill language, which I will share on the screen shortly, I just wanted to frame the issue for a moment. And the issue we have is not an issue that concerns our Constitution or our statutes. The issue we have concerns practice on the ground, what school districts are doing today, and how they're approaching this question. The U.S. Constitution requires that a generally available benefit, like tuition that goes to independent schools, cannot be denied to a school based on its religious status. The Vermont Constitution holds the same. You can't discriminate based on religious status. But the Vermont Constitution requires that before you district pays public funds to a school with a religious mission, before that happens, there has to be safeguards to ensure that money is not being used for worship or religious instruction or propagation of religion. So the U.S. Constitution and the Vermont Constitution are consistent on this question. Our statutes on tuition are consistent with our Constitution. And the problem that we're having, the school districts have been denying payment to these schools that have a religious mission based on their staffs. So when asked by the school or the parents of a student, can you pay tuition to Rice Memorial High School? Districts have been saying, no, because you're a religious school, no. And that's the problem. So we need, what this bill proposes to do is to give districts direction as to how to respond to that question correctly. And the correct response is to require, according to Professor Teachout, who you heard from last week, is to require school districts to receive a certification from those schools, not just those schools, from all approved independent schools, that says that the funds will not be used for the purpose of religious instruction, worship, or propagation. So by doing that, you have a uniform approach throughout the 100 and so school districts that we have in the state, and it clarifies the position. A number of court cases are happening right now because of this issue. And this bill is designed to make a statement by the legislature as to what the right direction is to avoid these problems going forward. Is that clear? Any questions about that before I proceed?
Yes, Senator Chittenden, please.
Thank you, Jim. That was very helpful. I received a call from a good friend of mine that was concerned about our discussions on this topic. And the core of their concern, I think you just addressed, is that this could be used to prevent what monies are currently allowed and going to some schools with religious missions. But your understanding of what we're doing here is to clean up the language and, if anything, allowing school districts to enable the sending of public monies to schools with religious missions, assuming they certify. So by no means could this bill be interpreted, based on what we understand so far, as prohibiting or preventing current monies that are going to some schools with some public monies going to schools with religious missions. That is not going to be affected by the intent of this bill. Is that a fair statement?
I would say yes. I would qualify that by saying that my understanding today is that money is not going to these schools to a religious mission because of confusion at school district level as to what the rules are. Now, whether or not the schools can certify that they won't use it for this purpose is a separate question, right? So assuming they can certify this, then they would be available for these funds. Okay.
Senator Chittenden, that's good. Okay, great. Any other questions? Senator Hooker.
Yes, Jim, could you just talk about the lawsuits and they're being brought on the basis of being denied the tuition?
Sure. So you have lawsuits happening in the courts. You also have appeals going to the State Board of Education because in some cases, school districts have the authority to allow, operating districts have the authority to send their children to another school. So you have two things going on: court cases and State Board of Education cases going on. And the theme of these cases is that the courts are basing their decisions on the record before them, okay? And the record before them is, in some cases, statements made by school districts to parents that they are unable to use tuition funds because of the status of the school. So the courts look at that and they say it's based upon discrimination based on status, and that's unconstitutional. Okay. Also, what's happening is on dual enrollment, which this bill now addresses too, but I don't propose to go through that today necessarily unless we have time. But dual enrollment, same thing's happening. Districts are saying you can't have dual enrollment to a student who goes to Rice Memorial High School because you're a religious school. Okay, that's not the correct statement to make, because actually, if the school was on public tuition, they could do dual enrollment, and the only reason they're not on public tuition is the schools are denying them based on the religious status. So it all comes back to the same question.
Is that helpful, Senator?
It is. And I know that we've talked about this before, but the idea that money sent to a school for dual enrollment, even though it's going to perhaps a college that is not certainly not religiously oriented, but that could kind of be used in place of money that's being spent for courses provided at the school. So that was, just a,
Yeah.
I guess, so right now, the money can go, but schools are saying it can't because
School districts are denying. Yeah,
because of the status of the school.
yeah, correct. Yep.
And we have, Mr. Demery, please correct me if I'm wrong. We have, if we were to do nothing, which is always an option, we would have school districts, we would wait for lawsuits to be settled, and
Yeah.
see how things play out. But the Constitution itself and both courts have said that these kinds of things have to happen. We just need to put the guidelines around them.
Yeah, that is correct. And if you did nothing, then recently, in the last month, the Agency of Education gave guidance to school districts on this topic, but that guidance is non-binding.
Mm-hmm.
The AOE doesn't feel it's in a position to instruct on this. It's really a school district decision. So there is something out there that could be helpful, but not coming from you, and what's out there now is non-binding. And what's happening too right now is, at least in one of the cases, you have a federal appeals court saying that you have to allow for tuition, basically, because you have discrimination based on status, but there are no safeguards to protect that money against religious uses for religious instruction. So you have a federal court saying you have to comply with the U.S. Constitution, which could violate the Vermont Constitution, because without the safeguards, you can't do that. So you have basically some districts are in the crosshair right now of two competing things. And without the guidance here, maybe they'll find their way through, but this is designed to give them clear guidance as to how to get through that.
Just take a quick trip back to the 1700s, Jim, and we'll let you lead this trip. Any idea, any thoughts on, in your study of the law and the Constitution, what the founders were thinking about this kind of thing?
I can't answer that question. There's been so much development of these principles over the last 200 years.
Yeah.
And 20 years ago, 30 years ago, the point that Senator Hooker was making about diversion of funds would have been a very relevant conversation. Today, the court doesn't worry about diversion of funds in this context. So things have changed a lot.
Sure.
And we've got cases that have just come up in the last year, big cases, Espinoza, one that Damien will talk about, that are just changing the whole landscape that we're working in.
Okay. Senator Chinden.
This is really helpful, Jim. So can it be said that this bill is designed to prevent school districts from discriminating against schools because of their religious mission?
Yes.
I love that. Thank you.
Yeah, yes, yeah. And so before I go to the bill, there's one more framing issue, which is you've talked before about having the certification requirement. It's been in the bill language. What's new about this bill language is it also now requires approved independent schools, regardless of their religious status. So approved independent schools, Burton, Rice Memorial High School, regardless of their mission, would have to comply with the same anti-discrimination laws that apply to public schools. in order to get the grant funds, the public tuition. That's new in this bill, and that's why you have the witnesses you have today to talk about that aspect of it. I've also added into this bill language about dual enrollment, but I won't cover that at the outset because I think you want to hear more about the discrimination issues, and we can cover that when we have time maybe later or next week, if that's okay.
Sure.
So with that, Jean, if I could share my screen, I'll pull up this document. Okay. Right here. Okay, yeah. Okay. Can people see this document?
Yes.
Good. Okay. Okay. So the bill now proposes to do three things. One, to ensure compliance with the U.S. and Vermont constitutions by clarifying that a school district is authorized to pay public tuition to a qualified school or program. Those words are kind of defined terms of statute, but what we're talking about here are independent schools for this conversation. Okay. Regardless of its religious status or affiliation, if the school or program has adequate safeguards to ensure that none of the tuition for which payment is requested has been or will be used to support religious instruction or worship or the propagation of religious views. Second, to prohibit a school district from paying public tuition to a qualified school program, again, regardless of status, unless the school or program complies with all federal and state anti-discrimination laws applicable to public schools. And third, clarify under what circumstances a school district shall make dual enrollment available to students who attend a school with a religious mission. Okay, so we've gone through this before, but let's go through it quickly again. We have some findings. So first finding is that the Vermont Constitution has a compelled support clause, which provides that no person can be compelled to support any place of worship contrary to the dictates of conscience. That applies to taxpayers. So taxpayers can't be compelled through their tax payments to support any place of worship. In this case of Chittenden Town versus Department of Education from 1999, the Vermont Supreme Court held that a school district may pay public tuition to a school with a religious mission under the compelled support clause if the school has adequate safeguards against the use of such funds for religious worship or instruction or the propagation of religious views. And the purpose of Section 2 below is to define adequate safeguards that a school district must employ to ensure that public
I found this on the web for Define Aqua Safeguard.
Sorry, my iPhone's going off. Sorry. The purpose of Section 2 is to ensure that safeguards are put in place by school districts. Okay. Section 2 is amending existing statute. It's Section 828, and that's the section that deals with tuition paid to approved schools. And unchanged, subsection A says, a school district shall not pay the tuition of a student except to a public school, an approved independent school, which is what we're focusing on, and then also to an approved school meeting education quality standards, a tutorial program, approved education program, or an independent school in another state. So all that's being covered here under our language, but we're really focused on this approved independent school part. So you can pay to an approved independent school. Now B is new language. It says a school district shall not pay tuition under subsection A of this section to any of the school programs identified in that subsection, regardless of religious status or affiliation, unless it receives certification from that school or program under subsection D of this section, which I'll come to. Provided that public schools that receive tuition from a school district are exempt. then there's language here that is designed to say, and we can focus on this language maybe at a future date, but it's designed to say that schools are permitted to give basically overview courses in religion. So this is not to say you can't teach religion at all. And that's what this language here is trying to express. The main topic for today, though, is here, which is that says, C, a school district shall not pay tuition under subsection A of this section to any of the schools or programs identified in that subsection, unless the school or program complies with all federal and state anti-discrimination laws applicable to public schools. And then lastly, in D, it says, in order for a school or program identified in that subsection to receive public tuition from a school district, it shall certify to the school district that none of the tuition for which payment is requested has been or will be used to support religious instruction or worship or the propagation of religious views, and that the school or program complies with all federal and state anti-discrimination laws applicable to public schools. This certification requirement shall not apply to public schools. So I'm going to stop sharing for a minute. And I just want to say that the topic for the witnesses coming next, I believe, is around the extent to which it's permissible to require these independent schools to comply with all anti-discrimination laws. What I will say is this provision is not outright saying they have to comply. It's a condition to receive public tuition. So it's not unconditional requirement, it's a condition to receive public funding. And that's the framework that I think we're talking about this in. So that was going to be it for my part of this, but I'm happy to take questions.
Yeah, so if I may, so if I had a child who was going to go to the St. Andrew's Episcopal School down the road or something, under this, if this were to pass as is, that St. Andrews would have to comply with anti-discrimination policies put forward by the state and federal government.
Mm-hmm.
Brian Jr. could enroll in Introduction to Religious Studies down there, but does that mean Brian Jr. cannot, or they would not allow him to take a class specific on teaching the New Testament or something like that?
Yeah, this is not designed to interfere with school's mission.
Okay.
Okay. So it comes to your question goes to the point of how does the independent school make the certification?
Yeah.
Okay. And the certification itself is one that as drafted has to be trusted because there's nothing more to it than providing certification.
Yeah.
Ways in which schools may approach that, I don't know. But for example, schools have capital funds for obviously improving their buildings and facilities and operations. They have food budgets. They have things that don't go to religious mission that schools just do. So they could segregate funds for that purpose, using this public tuition money for those purposes. They could say, look, 60% of our day is basically a secular thing, 40% is not. So we're going to accept 60% of the tuition, public tuition, and not the 40%. There are different ways they could do it. And this doesn't tell them how to do it because you heard from Professor Teachout last week, it gets very messy when you try to go in there and figure that out. So it's a question for the schools to decide how to comply with this certification requirement.
Other questions before we move on to, yes, please, Senator Lyons.
So this is such a complex area, but is there jurisprudence on, I mean, obviously we have the Chittenden decision, but then there are significantly more court cases relating to this. And I think of things like the prayer before the start of school or before a sports event and those things. So, suppose a child from a secular school can only play a sport if he or she is at Rice. And the rule of thumb is that there's always a prayer or a blessing before the game begins. Could that be considered a violation if some of the money is being used for the sports team?
That's a good question. I'm not an expert, frankly, in this area. So
It's
I have
okay.
several, several going.
It's probably not an answerable question, but I think it's probably the responsibility of schools to, when they certify that all of their staff are well informed about the meaning.
Right.
So, yeah.
They have to have some system in place, I think, to spend these funds in a way that does not contradict their certification.
Yeah.
Um,
Thank you. I mean, because despite how young I am, I do remember when Under God was put into the Pledge of Allegiance and the big fuss that was made about that by some of the agnostic people in the country. So,
Sure.
yeah.
It's hard to believe that you would.
Yes, it is, Senator.
Absolutely. Yes, Senator Chittenden, please.
I don't know how much, Jerry, you want to spend on this, how much time you want to spend on this, but to Senator Lyons' point, I think this is important for us as a committee to understand what we're talking about if this goes to the floor so we can defend it. In that example, I would understand as long as the prayer isn't anti-discriminatory, and even if by some chance somebody did say something inflammatory or discriminatory, sorry, not anti, but discriminatory, as long as the school didn't condone it and the school didn't require that same prayer every game, and they instead, in fact, addressed it, then it would be resolvable. And simultaneously, as long as they didn't require every student to conform to a prayer or to share the prayer, then it would still probably meet that certification process. Is that a fair way to stretch out her example?
Well, I would just say, I mean, the whole topic of prayer, or places or various things like that deal with religion in schools, is a very broad topic, right? We're talking today about a more narrow topic about use of public funds going to these types of schools and what they would need to do to comply. And again, there are lots of things you can go into probably as to these questions, but the bill doesn't do that. The bill is simply looking for certification and leaving those questions really over there, if you will.
Senator Hooker, did you have you're all set? Okay. Thank you, Jim. And I think we'll now move on to Mr. Leonard.
Good afternoon.
Good afternoon. How are you?
Going okay. It's
All right.
Friday, right?
Thanks for being with us. Appreciate it. Mr. Leonard, if you would remind us, just take us to the section again that you are have some expertise in, and give us your thoughts, that would be most appreciated.
Sure. So what I've been working with Jim on this is the requirement that the schools comply with the anti-discrimination, federal and state anti-discrimination laws. Mm-hmm. And what makes that sort of a uniquely complicated issue in this case is a series of cases that culminated most recently with the 2019-2020 Supreme Court session in a case called Morrissey Beru versus Our Lady of Guadalupe School. I reversed them in the title, but what that case was it was a case, it was two cases that were consolidated at the Supreme Court where Catholic elementary school 5th grade teachers had sued their schools in one case for age discrimination and in the other case for disability discrimination when their contracts weren't renewed. So what was at issue in that case was whether what's called the ministerial exception applied to those individuals. And what the ministerial exception is it's the idea that a religious institution, including a religious school, should be able to choose and, if necessary, remove a minister without government interference. In other words, the state or the government shouldn't be permitted to force a religious institution to keep a minister or a preacher or a rabbi who is teaching something contradictory to the dictates of the faith. And the state shouldn't be interfering in their decision about whether to continue employing someone in a ministerial role. This doctrine or this exception has gradually expanded over time. The sort of first landmark case in this was about someone whose title actually included the word minister. So they were actually named as a minister. In this case, neither of the teachers' titles indicated that they were a minister. They were both just 5th grade teachers. Neither of them had had formal religious training. And neither of them was held in an especially elevated role within the hierarchy of the religious institution. They were both just regular teachers. So from that standpoint, the plaintiffs in that case argued that they shouldn't be subject to that ministerial exception. But what the court basically focused on is, do they play a religious leadership role? And so they're looking at what do they do? And very importantly, Justice Alito, who wrote the majority opinion that in that case, focused on this sort of functional test. And he identified various things that they did during the day, including leading the students in prayer, taking them to Mass, helping them prepare for various religious events at the school, and then in some cases teaching the school's religion class, all as being ministerial roles. And thus, even though those individuals didn't have the formal title of minister, they weren't Catholic priests or nuns or anything like that. They were just regular teachers, and their contracts didn't even require them to be Catholic. He basically ruled that their role as teachers within that institution made them key to sort of the religious purpose of the school, and therefore found that because they had that role and because they performed some of these religious activities, they were subject to this ministerial exception, which meant, and this is the key point here, that the court could not consider the the discrimination claims that they'd filed. So in other words, the schools were exempt from federal discrimination laws under, in this case, the Age Discrimination and Employment Act and the Americans with Disabilities Act. But they've also applied this to the other civil rights anti-employment discrimination provisions. And so essentially what you've got here with this bill is you're requiring compliance with state and federal discrimination law. And I'm not aware of an instance where this has been applied to a state law, but under the supremacy clause of the Constitution, I would argue that the U.S. Constitution would win out if you had a state law that was unconstitutional. And so we cannot necessarily enforce an anti-discrimination law with respect to teachers at a religious institution. You might be able to with respect to someone like a custodian or someone who prepares and serves meals, someone who performs a purely administrative role. You might be able to apply the anti-discrimination laws to them, but the courts would, at least in my reading here, I think it's likely that the courts would, if you had a teacher or other person in some sort of educational role filing a discrimination claim, that they could potentially have their case dismissed under this ministerial exception. So it is a sort of complicated place where our protection of discrimination meets the First Amendment protections against the state interfering in the establishment of religion. And I know you have Bor Yang with you today, and she may have some other thoughts on this. But this to me kind of presents a little bit of a conundrum with this bill. Because you're asking for a self-certification, but are you also compelling them to do something that they're not required to do under the Constitution? Or are you simply saying, as provided by, the existing case law, you have to comply with the anti-discrimination provisions? So, another thing that's just worth pointing out is there is no rigid test that the courts apply on this. It's sort of a 4-factor test where they weigh the different factors I mentioned: the title, the training, the role within the religious institution, and then their actual functional role. And so you could find on different facts with a different school, that Episcopalian school down the road from you, Mr. Chair, that in that case, the individual wasn't fulfilling a religious role and the anti-discrimination laws do apply. So this could be very fact specific depending on an individual's role and what purposes they fulfill during their day. I see there's a question from Senator Lyons already.
Yes, good. Please, Senator Lyons.
Not just one, 1,000. I do have 2 questions. I'll ask the broader question. If the state of Vermont had an integrated equal rights amendment that protected people regardless of disability, if we put disability in, or ethnic and racial background, if we had that, would that provide for the discrimination protection that we're seeking in this bill, anti-discrimination protection?
Again, I think what you're running into here is you're going to deal with an issue where the court or the judicial body that considers this is going to have to balance the institution's First Amendment rights versus the right to be free from discrimination of the individual. And so I'm not sure that I can give you a clear answer one way or the other, but I think any court that considers this is going to be considering the sort of competing constitutional and legal factors here. Another thing to just note is that a state constitution, if you have a state constitution that directly contradicts a right that's provided under the federal constitution, I think there's a very strong argument that the federal right wins out. So you can't deprive someone of their rights under the US Constitution through state action. But it would definitely be an interesting case.
Wouldn't that be fun? But my other question, I think you've answered, that by giving a certification that they are not violating they aren't using the money for religious purposes, would it be considered that the school is effectively waiving its rights? So if you're certifying that you're not using it, that means that you're adhering to what the law is requiring, and therefore you would be saying, I waive my rights in this instance as long as I'm adhering to the requirements of the statute.
I'm not sure that I would read an implied waiver into the certification that you're not using the money for religious purposes. So I don't have a lot of background in education law, for example, but in the area where I am more familiar in labor law, before it was struck down at the US Supreme Court, for many years, when agency fees were legal in the country, there was a test that was set out where you had to be able to show that you weren't using the money collected. So an agency fee is a compelled fee paid to the union by non-members for the representative services. And you had to show that the union wasn't using it for speech activities, because that would have violated the individual's right to free speech. So for example, if I was in the bargaining unit, but I was anti-union, I just happened to be represented by one, I didn't have to pay for their political action, but I did have to pay for their services. Now that's been struck down, so it's aside. But I think when you're doing that certification, and I wasn't here for your other testimony, what you may see is, so our religious instruction is funded by the diocese of the local diocese. And our math and science and English curriculum and our foreign languages curriculum, that's funded by tuition. So that could be a way that you could meet, at least from my standpoint, not knowing the education law very well, that could be a way that you could meet that standard, potentially.
Senator Lyons, are you comfortable with
Yep. No, I'm not comfortable, but I get it. I understand.
Yeah.
Thank you.
Okay, thank you. Senator Hooker.
Oh, just a question about the draft that we're on, because I don't seem to have the one that's up on the screen. I don't know if was there another draft that was sent, Jim?
Yeah, it should be. Is it not posted?
It just doesn't have the yellow on it. I think it's the same thing though.
No, I don't see well, I don't know. Maybe I'm not looking.
Draft 3.1.
It's draft 3.2.
Yeah, I have 3.1 on.
Yeah.
On our site. And I did want to ask.
Just a second. Jeannie, would you mind putting 3.2 up?
I'm looking to see if I have it.
Thank you. Senator Hooker.
That Damian, you were talking about the 4 things that would put a person under like ministerial exception.
Mm-hmm.
Are they all 4 of them, 2 of the 4, whatever? And then you talked about teachers who weren't even religious, had no religious affiliation. So say a math teacher who doesn't do the prayer, doesn't take the kids to mass, doesn't do any of that. Would that person be protected under the anti-discrimination?
So in that case, I think that there is an argument, a strong argument that they are, but it hasn't, to my knowledge, been addressed in the courts yet. Bohr may be able to give you more insight onto this. She certainly has a greater amount of expertise in anti-discrimination law than I do. But in this case, I think it was important to this case that the teachers here prayed with their students, attended Mass with them, and prepared them for participation in other religious activities at the school. So in this case, they did have some religious function, and one of the teachers taught the religion class that was required for her fifth graders from the textbook, although she, she argued in court that she was just basically providing them the exercises in the textbook. She wasn't actually providing them the kind of instruction that, like a youth minister or a priest or rabbi might provide. But the court rejected that argument and said, no, you're performing religious activities that are at the core of the school's religious mission. So therefore you're covered. The dissenting justices in the case, Justices Sotomayor and the late Justice Ginsburg, in their dissent, they kind of raised the question, well, where is the line? Is a coach who leads the football or the track team in a prayer before the competition, are they a minister? And what about, and they laid out a series of sort of what ifs. Where does this religious function end, or are we just going to, is it up to the institution to say where that function ends? Because and so I think that's an open question at this point. But I think that there's a strong argument if you have a teacher who teaches nothing but, the calculus and algebra curriculum, and that's all they do, then potentially they are not covered by this ministerial exception. In the same way that a custodial staff member who provides no religious instruction, but just happens to work in a building owned by a religious institution, has a strong argument that they are not covered by the ministerial exception because they're not performing a ministerial role.
Thank you.
Mr. Leonard, say something, would you, about students in religious institutions? In other words, gay students that may want to, attend a dance together, students who might be transitioning. Say something, if you would, about, because again, what we're trying to do with this is to protect those students.
Mm-hmm. I think I would defer to Bohr there,
Okay.
because it's outside of employment law, and my very limited experience comes from attending a Catholic university.
Okay.
So I don't know the law here. So I would defer to her.
Mr. Desmarais, you had your hand up.
Yeah, if I could just say that it's not the case in this bill language that we would be proposing to apply the anti-discrimination laws directly to these schools. It's not like we're coming in here saying, independent schools, you have to comply with all, and it is only, they will only be applied as a condition of taking public money. So it's like, I just want to frame it that way because I'm hearing everything that Damien is saying, but I'm wondering if that all stands true if the requirement is a condition of a privilege. It's a condition of getting public funds, as opposed to a strict requirement just to comply. And the same thing that we do on the public accommodation side, same question, it's really around conditioning public monies on this requirement, not an outright requirement just to comply.
Yeah, and that's outside of my area of expertise. I might defer to David Hall on that one. I mean, it's worth noting our anti-discrimination laws, at least ostensibly, with a couple of minor exceptions, or not minor, but a couple of limited exceptions. That was the wrong choice of words there. But a couple of limited exceptions do apply to all employers in the state. The key piece here is that the federal courts, the U.S. Supreme Court, has established this ministerial exception under the First Amendment, and so that's kind of the interesting area there for a religious institution. And there have been a number of cases which I just can't pretend to know all the ins and outs of, regarding when a religious institution has to provide certain types of health protections, et cetera. And this is probably an area where Bohr can give you a little bit better sense of some of the ins and outs, and David may be able to talk about, whether you can condition the receipt of public funds on something like this. I mean, at least on the surface, the school needs to abide by the anti-discrimination laws. The catch is they don't need to do it for someone who is a minister.
Right. So right now, as is, if you have St. Andrew's Episcopal School, and you're a student, that school has to abide by the state's anti-discrimination policies, which protect members of the LGBTQ community. But as it relates to the ministerial role, it isn't protecting a faculty member.
Yeah, although
answer the first part by itself, is it protecting the students?
I can't answer the question on the students. I can answer for employees.
I see. Okay.
And just with respect to state law, we do have an express exemption in our state law that discrimination on the basis of sexual orientation and gender identity shall not be construed to prohibit or prevent an organization operated for charitable or educational purposes, and that is operated, supervised, or controlled by or in connection with a religious organization, from giving preference to persons of the same religion or denomination, or from taking any action with respect to employment matters that is calculated by the organization to promote the religious principles for which it is established or maintained. So in other words, there is a limitation on our protections against employment discrimination on the basis of sexual orientation and gender identity already in statute with respect to religious organizations. If the decision not to, for example, hire someone of a certain sexual orientation or gender identity is calculated to promote the religious principles of the organization. So that's another thing worth noting here before we even get to that. And again, with respect to the students, I really need to defer to Bohr.
All right, I'm going to stop there, but I'd like you to stay on, Mr. Leonard. Ms. Yang, would you mind joining us? It sounds like you might have be able to direct us. Good afternoon. Welcome to Senate Education. You have hopefully heard some of this conversation. You know a little bit about what we're trying to do here. We have some answers from Mr. Leonard, but he's mentioned your name a few times as possibly being able to help us navigate this. So any assistance you can give would be greatly appreciated.
Yeah, thank you so much for inviting me here today. Just for the record, Bohr Gang, the Executive Director of the Vermont Human Rights Commission. And I have been able to listen, and I think both Jim and Damien have done an excellent job. And I think the reality here is that this is a really tough area with competing interests and competing rights. And as Damien has mentioned, the US Constitution trumps every time. And a lot of these cases are interpreting the US Constitution. And so when there are competing rights, that if you have the US Constitution on your side, most of the time you're going to prevail. I do want to mention that both the Vermont Fair Employment Practices Act and the Vermont Fair Housing and Public Accommodations Laws, which is our anti-discrimination laws in housing and places of public accommodations, all set forth exemptions around sexual orientation and gender identity. So places of public accommodations include schools, any school. We haven't said that that's only schools that receive public funds or non-religious schools. It's any school really, but that we have set forth an exemption for religious institutions to discriminate as it relates to same-sex marriage or same-sex relationships. And I'm trying to look for the exact language so I can read it to you here in a second. But the reality is we haven't had a lot of cases that interpret that. It is possible that a school that receives money could use that exemption to discriminate against kids who are LGBTQ. That is the reality when you have an exemption such as that. So I wanted to point out some important cases. Some of this is redundant because Damon mentioned it too, but the U.S. Supreme Court case of Hosanna Tabor Evangelical Lutheran Church was involved a teacher who filed a disability discrimination claim and was retaliated against. And that was the case where the U.S. Supreme Court said, well, if you are a minister and you have that title, then we have no authority to judge and to decide whether this particular institution has engaged in discrimination. They're basically saying, we wash our hands, we have no right to make a decision here. And what follows is the case that Damien mentioned, Our Lady of Guadalupe School, where the court then completely broadens the definition of who is a minister. So it's someone who doesn't even have to be Catholic, maybe doesn't even receive the religious training, who certainly don't have the title as ministers, but play some important religious role, are now captured within that exception. And so I would love to think that maybe a custodian or a math teacher would not fall within that exception, but I don't feel really confident that that would necessarily be the case when they work at a religious institution. So we're not sure. Another case that I think it's important to highlight is the St. Johnsbury Academy case versus DH. So, before I do that, I want to just mention that the teachers in these cases were discriminated against on the basis of disability. One teacher was aging, so it was an age discrimination case. And in another case, the teacher had breast cancer and then was terminated. So I'm not aware of any religious tenets that would permit that kind of discrimination, but nevertheless, we're not talking about sexual orientation or gender identity discrimination here. We're talking about religious institutions really discriminating against teachers based on disability or age or otherwise. Okay, so the St. Johnsbury Academy case is an important Second Circuit court case. It involves a student who has cerebral palsy and other disabilities. And St. Johnsbury Academy was really the school that they had chosen to go to. And this particular student was on an IEP plan, which is covered under the IDEA laws, that said that they had to be integrated into mainstream classrooms. But St. Johnsbury Academy had a rule that says you can only join the mainstream classrooms if you're functioning at like the 5th grade level. And this particular student, because of their disabilities and their IEP plan, could not meet that requirement, and then they were excluded from the mainstream classroom. And that case went all the way to the Second Circuit. And what the Academy argued in that case was that the law doesn't apply to them. The IDEA doesn't apply to independent schools. And they won. So the Second Circuit Court decision was that the IDEA laws do not apply to independent schools. And it entirely ignored the fact that private institutions like St. Johnsbury probably get the majority of their funds from public funds. There's a lot of independent schools in Vermont that are primarily funded through public dollars. And so one could argue, and I think that the student did argue that it essentially was operating like a public school, but nevertheless, the Second Circuit Court read that it wasn't. That student also raised violations of the Section 504 of the Rehabilitation Act. And again, there the Second Circuit Court said that schools have the right to set certain qualifications. This kid didn't meet the qualifications, and so they weren't going to review the 504 claims either. And so the student lost. And I think that's important because the question ultimately is, what does certification mean? What value is it? Is it just a pro forma promise? If there's no jurisdiction to review a school for firing their teachers, or there's no jurisdiction to review a school for not permitting certain activities or not admitting certain students, if there's no jurisdiction over that, are they essentially in compliance and therefore they can certify that they are in compliance, or are they not in compliance? And I think that is sort of a really difficult position. I certainly would support this language because I think it's important that all of our kids have real choice, regardless of their disabilities, regardless of their sexual orientation or gender identity, to be able to choose which schools they go to if they live in a place where there is that choice. But I don't feel particularly hopeful because of the case law. The secondary question I have is more practical, which is who really enforces the certification? I think Jim mentioned that about a promise from the schools that they're complying with the anti-discrimination laws, but what does it mean when they make that promise, but they actually aren't in compliance? How do we determine who is in compliance and who's not? What happens when they've already received public dollars and then they're not in compliance? And what are we looking to in terms of determining compliance? I'll just give you one example. HUD requires that entities that received federal dollars for housing do not violate any anti-discrimination laws. And so they do require a similar kind of certification from those entities, but they also reach out to agencies like the Human Rights Commission to see if we've made a determination that those entities have violated the anti-discrimination laws in deciding whether or not to renew those grants and those funding for the next session. So I'm afraid I've thrown out more questions out there, but this more than probably answered them. But the reality of the fact is that the case law is not particularly helpful for all kids in Vermont, and I'm not sure I know how to reconcile that.
Well, our only question to you is, what should we do?
Right. Yeah.
So it sounds like you would suggest that we move along. I think your point's a good one. How do you certify these? So you put out these certifications. Who's going to check on them? What sort? It is but as Mr. Desmarais has said all along, this is a bit of the honest policy. Make sure we're committed to doing the right thing here. We're going to certify, and students are going to come here and not receive, religious instruction with tax dollars. But to your good point, the practical piece of that is, how do you follow up on that? How do you check on it? If we were to put the anti-discrimination language in, it sounds also like, this ends up in a court's going to immediately decide against us.
I don't think it's going to be clear one way or the other. I certainly think I would move forward
Okay.
if I were you. That's
Yep.
just me. Because I do think that the purpose and intent of this language is to be inclusive and protective.
Mhm.
And I always say, let's go bold, Vermont, and the courts can determine this and interpret it later. And courts are always changing too, by the way. Right? If we had a different kind of makeup on the US Supreme Court, the decisions might have gone differently. Nevertheless, this is where we're at. And so my feeling is you put this sort of certification requirement out there, there's a good chance that schools will voluntarily just comply with the anti-discrimination laws. And so even if there was no enforcement piece to it,
Yeah.
I still think it's a good thing. I would suggest that you add some type of enforcement. I'm just thinking about what happened. Do they pay back those public funds
Right.
if they're later discovered to have discriminated? What happens to all the kids in the interim if there is a determination that a school has violated the anti-discrimination laws? Again, here the ministerial exception still potentially leaves a lot of employees who could be covered.
Right.
Whether I feel hopeful about that or not, doesn't matter. I mean, there's still the legal argument that it could cover several employees. I also think that we're talking a lot about religious institutions, but we have a lot of non-religious independent schools here too, who would fall under this, and there's value in that, absolutely.
Question. Senator Lyons, please.
Actually, Bor, thank you. You answered most of my questions regarding certification and whether we should include anything more in the bill. And it sounds like you're from your perspective that if we remain silent on anti-discrimination, that it's implied in the bill that folks are following in the heading or in the findings that folks might be following anti-discrimination procedures in their schools. And so I think I agree with you on this one. I think it's really important that we go forward. But my question, I do have a question, and the question I asked earlier from your knowledge and work, if there is a certification, doesn't the certification mean that the school is willing to adhere to all the requirements of federal and of state law? I'm going to leave federal out for now because we've got the Supreme Court hanging over us, but can we say something about the fact that the certification does mean that they will adhere to the same requirements that publicly funded institutions are adhering to, or some similar type language?
I think that the way I'm reading the current draft is that is what you mean by it. I think the question for me, not really me, because I would interpret it that way. I think the question for some schools, particularly religious schools, is, does that mean, because there's no jurisdiction to determine whether or not they are in compliance, does that mean that they essentially are? If you have no court that can decide whether you're in compliance or not because you have a First Amendment right, are you actually then in compliance, or does that mean you're not? And I think that is the odd piece here. But again, there's a lot of independent schools in Vermont that get public funds and that are not religious, and they would fall under that, except where it comes down to the special education cases. Again, because we have that Second Circuit court case that has decided that the IDEA laws do not apply to independent schools in that way, that it's still the public entity's job to make sure that kids who are in special education are still receiving all of those services that they're required to. But yeah, I mean, I think that's a hard question, because what does it mean to be in compliance with the anti-discrimination laws?
And then what does it mean in terms of the funding if, as you said, that maybe they lose their funding? I mean, could the state withhold funding as a result of a lack of certification going forward?
That's a really great question. And I read Professor Teachout's testimony a little bit about that. I just want to say, I'm not clear that removing funding because a religious institution has a First Amendment right to discriminate is not a violation of the First Amendment. And so I think that's a tough space. That's where those recent cases that were discussed comes in, is like, can you then say, well, if you're going to take public fundings, you have to then not discriminate, and religious institutions say we have the right to discriminate. That's our First Amendment right. And so you can't if we have a First Amendment right, you can't then remove funding from us, because then you're discriminating against us based on religion. And so
So the religious organization has the right to discriminate against very vulnerable populations based on something in their structure and belief. Anyway, we won't go there.
I don't even think it has to do, remember, these cases were about disability, and these cases were about breast cancer and age. So we're not even talking about religious institutions that could rely on some kind of tenet that says it's against our philosophy and our religious tenets. I mean, it's age and disability, and they have the First Amendment right to sort of do that.
The key piece in those cases was that they have a First Amendment right to choose their ministers. So, which I think, that is the question that, again, really comes down to who is a minister. And the most recent case was a significant sort of expansion from what had previously been covered in court cases. But it also, it's basically saying, if you're a religious school and you have someone who provides some form of religious activity, then they are very likely covered by that ministerial exception there, and that allows the religious institution to choose whether to keep them on as a minister or not, because they have the right to choose their own ministers. The state, what the court is saying is the state can't interfere in that right. So.
And of course, the U.S. Supreme Court didn't set out the factors. They're just interpreting it case by case. And so that's why when Damien said that it's possible that a custodian could still not be a minister, and I said, who knows? It's possible that a custodian whose job is primarily secular in nature is present for prayers and then is considered to play an important role in that.
Yeah. Damien, did you have some?
I just wanted to say I have to leave for my next hearing. So
yeah. No, thank you. Thank you. Appreciate this. Yeah. Other questions for Ms. Yang? Senator Perchlik.
Yeah, thanks, Ms. Yang. You answered most of my questions, I think, with your responses to Senator Lyon's questions, and I think we should keep the language in and kind of see what the courts do. But I thought it was interesting, your point about if we add something about how we determine if schools are in compliance. I mean, I guess it would be if they're found in violation of one of the anti-discrimination laws, then they would be not in compliance. And if that's sufficient, or if you feel like we should, and if you're willing to suggest language that we should add about that, how we determine if they're in compliance or not.
Yeah, I think the question is who would be making that determination as to whether someone is in compliance with discrimination. Obviously, at the local level, they would be looking to see if the certification is accurate. But do you want an agency like the Human Rights Commission, whose job is to make kind of that decision, but we aren't a court and we don't offer an administrative hearing? Or are people not in compliance only once a court in Vermont or a federal court has determined that they have violated the anti-discrimination laws? So I mentioned earlier that HUD would look to just us. HUD is not looking for a court determination that someone has violated the anti-discrimination laws. HUD relies on agencies like the Human Rights Commission to make kind of that preliminary decision. The value of using an entity like the Human Rights Commission to determine whether discrimination has occurred is that it captures a lot more cases, because many cases come through the HRC that doesn't actually get litigated. And so that might be valuable. And because so many people are without financial resources, the chances that they are going to file a case in court is less likely. And so I certainly think that that could be helpful. I will tell you that if we had a case involving a religious institution firing a teacher, that although actually I should say that case would most likely go to the Civil Rights Unit at the Attorney General's office, because we oversee state government employees, and there's a good chance that that's the kind of case that they would receive. If I were to see something like that, I probably wouldn't even accept it for an investigation, because the US Supreme Court has already determined that there's no recourse in such a case. But absent that kind of example, I certainly think that using entities like HUD, EEOC, or the Human Rights Commission to determine compliance is important, because you're going to capture a lot more cases.
If it pleases the chair, would you be willing to give us some language on that, or examples from what HUD does or something like that?
Sure, I could certainly do a little bit of that research. Yeah.
That would be great. Thank you for suggesting a Senator Perchlik, and thanks for accepting the offer, Ms. Yang. I wonder also if you, and perhaps in working with our Ledge Council, might have some language around the compliance piece, yes, and then what's the enforcement piece look like? In other words, what happens when things aren't compliant? What is that, what then are you thinking about?
Yeah.
Can I just interject there? So remember that this is in the context of only providing public funds. So this isn't an outright requirement to comply with these laws. So the consequence of non-compliance, I would guess, would be to have make the school pay back the public funds they received during the period that they were out of compliance. Because it's not like a criminal or civil action here.
Right. Yeah. No, I think that's a good point. And maybe that's then what we should just have drafted up and put in there. Yeah, I think that's, because I do think, sorry, go ahead, Ms. Yang.
No, please, I don't mean to interrupt you.
No, please interrupt. You're not interrupting, you're helping us.
The problem that you might run into is you have some independent schools in Vermont who are primarily funded almost 90% by public funds. And if you find that they cannot certify, what are you shutting down that school? Are you removing all public funds, or only the public funds as it relates to that particular student who was discriminated against?
The way the bill is written, it would take you can't receive public funds unless you make the certification. Right. So to your point, they'd be losing all their public funding if they can't certify.
So then they're going to go bankrupt. And which maybe we don't care about, except all of those kids that live there don't have another school to necessarily go to.
it might be important that the way I read it now is that it says you have to certify, but as far as the discrimination, it just says that you're in compliance with all federal and state discrimination laws, which is maybe a distinction that has no meaning, but that's the way it's worded now. Well,
Yeah.
you're certifying one thing and then you're just in compliance with the discrimination laws. So I figured that's why some language on how to figure out if they're in compliance or not is important.
Yeah,
And then-
I think if compliance isn't truly connected to certification, the certification is meaningless.
Right.
Well, the certification is about the religious instruction, not about the discrimination.
Oh, no, it is, right? Am I reading the right draft? Certification is connected
Maybe I'm
to
not
the.
reading the right draft.
Yeah, it's both. It's both.
Yeah.
No, this is very helpful, incredible. I appreciate the dialogue. So if we could leave it for at least today, that you will work with Mr. Desmarais to get us some different language, some new language, and then we'll look at that language next week. I do think, unless there's an objection from the committee, I would be surprised if when we do pass something out, I do think it makes sense for Senate Judiciary to see it, and for them also to have an opportunity. For new senators, one of the things that can be very helpful when you get something that can be complicated, to have another committee see it. You also, if they're endorsing it, you've got, close to those 15 votes, if you will. First of all, it gives people comfort that, another committee of jurisdiction, in this case, the judiciary has seen it, but then you add, perhaps if we get, if we were to get our 6, we get judiciary's 5, we're getting close to that 15 or 16 by the time we get to the floor. So, there's some strategy there, and as well as some comfort around another group of eyes. So thank you both for talking to us about this. I think right now, Mr. Hall, we will hold off on you, but we will likely have you back because this is not the end of this conversation. And committee, if you don't mind, 10-minute break, and then we will return to, so that'll be 10 minutes too. And then we'll return to our conversation with joint fiscal, or start our conversation with joint fiscal.
Thank you, Boar.
Thank you all. Good luck.
Thank
Thanks
you,
a million.
Yeah.
Really appreciate it. Okay, good afternoon. Welcome back to Senate Education. We have with us for a little while Ms. Benham and Mr. Klein from Joint Fiscal. As I mentioned to these two individuals yesterday, we had, and to bring everyone back to yesterday's conversation, as we work on this letter to appropriations, there were questions around, do we need to raise taxes for these new dollars? What are the sources of these new dollars? What funds are they coming from? That kind of thing. And so just to, before we turn the floor over to the two of you, a couple of things. Senator Lyons, I am looking to possibly call in a favor, and we are, with our hope to get this to appropriations later today, there are two things where the Department of Health would need to weigh in, and the Department of Health, understandably, is very busy with COVID-related issues and couldn't come this afternoon. I'm wondering if need be, if we were to pull the two pieces of health out of this, that would be the first and second, might your committee be willing to take up those issues? And if not, that's fine also, because we could send some of these issues today and then some more next week. But just something for you to think about, see what you might want traded for that. Or if you just want to do it out of the goodness of your heart, which is also fine.
I have a very cold heart.
That we know is not true. All right, so we can chat about that, but I just wanted.
Yeah, no, I'm glad to consider that, of course.
So with that, Ms. Benham and Mr. Klein, welcome to Senate Education.
Well, thank you for having us.
Thank you.
So my question is, do you tend to like to have things on the screen, or do you like us to send it out, or what's your proclivity with sheets?
If committee members have it in front of them, it would be ideal. In other words, on their iPads or laptops.
Okay.
But if
So,
that's not possible, or if it's
yeah,
something.
no, it's totally possible. Jean, do you have it and you want to send it out, or should we tell us what makes sense?
It's posted.
Ah, excellent. Even better.
Okay, great.
Let's go.
So let's just give everyone a minute to get to the page, and under today's date, Friday, February 19th, I see it is under Catherine Benham's name. Great.
Okay. And now mine has to.
Ms. Benham, what is that beautiful view behind you?
That would be Sugar Bush,
Oh, it is.
which is not too far away, but I have yet to ski this year for many reasons, but I like to look at it.
It's absolutely beautiful. And
Yeah,
Steve,
thank
your background is stunning. I mean, absolutely stunning.
It's not very impressive. It's a kitchen, and I happen to have one plant that is hard to kill. But anyway.
All right, take it away.
Great. So why don't we go through this? What we tried to do is just talk about some of the money you have in your universe, and that's what we'll do. And I'll just jump into it, and then I'll have Catherine sort of kibitz if there's areas that she wants to go into more. The first thing I just on top of the chart is when last year, as you probably, well, as the Education Committee approved money for Department of Education in 3 tranches. They gave money to HVAC, which in 3 different levels. I think it totaled up to about 17 million or so. And then they gave money to the schools, 88 million, and some money for food and nutrition in schools. The HVAC money was all spent. Efficiency Vermont spent it. They have about a $14 to $18 million waiting list, basically, or idea that they could use more. And I know that the Senate Appropriations Committee just heard it, and Senate House Appropriations Committee just stuck it in their COVID relief bill to put to respond to that. And I'll just explain how, because the 88 million that was given to the schools to help with COVID, not all of it was used. There was about a little over 15 million left. So the proposal the AOE has made is to take the 15 million from the LEA component and move it into the HVAC area. So that is it's reallocation, and that reallocation is in the House COVID recovery bill. And I think the Senate is amenable to it too. So that's the end of the CRF money. Then.
So just a clarification, if you just a request, as you go through things, would you just let us know, all right, where, when you say the COVID relief bill,
yep,
where that is it done? Are
sure.
Just so we all have a level of, the fluidity, if you will, of some of these.
Okay, and that's a great point. I mean, this is a very strange year. This is a year where you have already been through essentially an endless summer and an endless session, and it seems to be continuing. And so we normally do a budget adjustment, and then we do a big bill. Well, there was a budget adjustment that is coming out in this. It may have already been dealt with today in the Senate.
We did.
And that's pretty much closed. But then, since the big bill doesn't usually happen in May, there was a number of other things that people felt were urgent to sort of make happen prior to the big bill. And so that we're calling that the COVID recovery bill for right now. I think the House might come up with a longer name. And that bill is supposed to pass the House next week, come over to the Senate and pass the Senate and be done sometime in March. And that's to sort of get a jump on Vermont has an amazingly short summer season. And for example, in this HVAC world, it's much easier to do this when the students aren't there. And so it takes a long time to order the equipment. So that the thought was, if we could get this out sooner, then there'll be a better chance that a lot of this can be done before the school open in the fall.
Great.
And there's other elements of that bill in that same area. There's a couple of, I think money will go to BHCB that has some housing projects that are able to be put in the ground today. And so it's a variety of things where there's some type of reason why it'd be better to do it sooner. And so that's the COVID recovery bill, and there'll be further appropriations in the budget. And the budget will have items that are effective on passage, which will happen in early May. And then there'll be stuff that happens July 1st. And so those are the BA, the budget adjustment, which is just about done, this COVID recovery bill, the two stages you normally get in the budget, which is the meet on passage and the, and then there may be more, and we'll talk about that later.
Yeah. Okay, Senator Hooker.
Thanks. Steve, you said there were 3 tranches and the third one being nutrition. And I noticed your note that says child nutrition emergency funds are not addressed here. But can you tell us how much that was and whether or not it was all used?
In the bill, there was $4 million set aside for that, and it ended up not getting used because I think they had other federal money come in that paid for that. Okay. And I think that the same thing seems to be occurring. There's other resources in the schools, but I'm really not an expert on that. I don't know the latest on the child nutrition issue in the schools.
And with regard to this next budget that's coming out, I think we've been calling it the expedited budget. Is this the same?
I think whatever name works for you. Yeah, I don't really, it'll have a name by Monday.
Yeah. Okay.
Well, no, it's a good question. It's a good clarifying question. And yes, so Senator Kitchell and Senators Kitchell and Ballant have been referring to it as the expedited budget.
Okay, sure. So the House and Senate will hopefully agree on a name.
Right.
And then we can move on from that one. Okay, so that's the sort of little CRF kicker that I want to do. Then we have this strange land of ESSER, which is the
Elementary and Secondary School Emergency Relief Fund.
Yeah, and so there were 2 ESSER bills. And actually there are 2 bills that had ESSER money. One is the relief bill that passed in March last year, and that was what we had, 1.25 billion of CRF money, plus it had some money for education. And then in December 27th of this year, there's another bill that passed, the relief bill that we're all dealing with now. So we call those the ESSER 1 and the ESSER 2. And so then as we talk about this, we'll be talking about ESSER 1 and ESSER 2 money. So the first ESSER bill had 27 million or so that went out, was to go out to schools, to LEAs. And that was, I think, Title I, just go out on a Title I schedule board. And then 10%, it was really 31, but 10% went to the Department of Education. It was sort of money that they could spend. And the ESSER 1 money, the 27 million, normally that came last March. It has not gone out yet. It's going out right about now. And what happened was, since the CRF money came in, and the CRF money had a deadline of December, there was a lot of pressure to get the CRF money out because that, had that quality of disappearing. It as of December, if you didn't spend it, it would no longer be there. So all the schools spent all their time spending the CRF money with the understanding that this money would be, and that would cover the sort of COVID needs up through December, and then they could use the ESSER 1 money for the sort of January to June money. So one of the things that happened, obviously we all know now that CRF got extended for another year, but that's what happened. They basically focused on that, got all but 15 million or so out of the 88 million. And then now they're putting out the ESSER 1 money, the 27 million. And what we're also noting is we had assumed in the education fund that spending would grow at a rate of about 2.7% in fiscal year 22. And it's not, it's growing at a lower rate. So we think what's happened, because they all knew about the 27 million, and they also knew about the money they got from the CRF. And we think that a lot of that money probably went to, most of it went to CRF type needs. Some of it might have gone to sort of creating capacity to come in with a lower budget in March. So we're seeing that. We're going to have to revise the balance sheet. And what will happen is, if you keep taxes at the same level as last year, you will have extra money on the bottom line of the ed fund. So that's one source we don't really have broken out yet, because we haven't seen the final numbers of what school spending will be. But once school spending is in, assuming you keep it a level tax rate, there'll be money there. There'll be money that you can essentially utilize. So we're not really, that's just something that'll be more useful for the Senate than the House because of the timing of the process, that we won't know it till town meeting week and then a little after. So that's just something there. So when we get to ESSER 1, as I said, 27 million goes out. A little over $4 million is left, or I think, actually, I have the wrong sheet up. It's about, and of that they spent, actually, Catherine, why don't you go into that? Because I pull up the other sheet.
I don't know what, I'm sorry, Steve.
I'm just saying the ESSER, the administration had, if that had $4 million or $3 left of the administration money.
Oh, you're talking, so we're now down to the state agency ESSER funds.
Yeah, I was going to do all of ESSER 1, and then I was going to come back to it.
Okay, well, so let's go. So they were appropriated 3.1 and they've used 1.1. So they're at the age, I'm on line 6. So they have available 2 million left. And these are funds that they can, the agency is allowed to use for, it's not going to the school districts. It's actually, we can have a little more say over how it's spent. And then going down to the line 9, which is the administration part of ESSER 1, that an agency itself is allowed to keep, I think it's half of that, I can't remember the amount, to actually for their own personal expenses. So that's they have spent all of ESSER 1 on that piece of it.
Yeah.
So now are you?
Yeah, no, I think I'm up to they get 1/2 of 1%. So we think of ESSER 1, you have the 27 million that went to the schools, you have the money as kept at the federal level, and then you have the 0.5% of administration. I tell you, I am, let me pull up the different sheet here. Okay. Yeah. So on the ESSER 2, you have a much bigger pot of money. You had 127 million total, 114 goes to schools, and there was about 12 million that was for the administration, and then a different amount for the 12 million for statewide set aside, and then an administrative amount. We'll come back to that in gear later on. Yeah. So the 27 million went out. The 114 million has not gone out. We didn't even know about it till early January. So we don't think that's really part of the budgets that any school has talked about, used, or it certainly has. The RFP hasn't even gone out yet. So it's sort of extra money that schools are going to get. And we'll come back to that because that's a real opportunity. But so you have these two pots of money at the executive branch, one of which was the ESSER 1 money, which there's some unspent. And then you have the ESSER 2 money, of which in budget adjustment, you spent 3.5 million to meet the needs of Burlington, to help out with Burlington's PCB issue. You'll see the House is working on a proposal to spend some of that money for school construction, but there's a fair amount left, and it is an interesting situation because the ESSER was a grant, and it was an accepted grant, and so the administration, if we don't do anything, the administration has that grant and they can spend it. But it is its resources. The legislature can weigh in, and even the administration, in bringing the Burlington 3.5 million to the legislature, sort of recognize the role of the legislature in determining how that money is used. So that's the first pot of money, those two statewide chunks that are essentially there that you can spend. Any questions now? I don't want to get too far ahead before I
do.
Senator Chittenden.
So just real quick, you said the administration. You mean the Governor Scott administration, or are we talking federal money? We're talking Washington D.C. the administration.
So this is all federal money. It came to Vermont in grants, and so now when it says it's for the administration, it's sitting in the state agency AOE, and it's in our administration, if that's the question. And so when it's federal dollars that they would allocate if we don't, but it's definitely allocable by us. So if you think about the two state agency ESSERs, you can see the 2 million from the first ESSER and the 9.2 from the second ESSER, 11.2 million available. If you look at if the House ends up spending some on school construction, that'll be something you could discuss, but it's money that's there. And it's fairly flexible money. And the purposes of ESSER money is very broad, 15 purposes. It's hard to find something you couldn't fit in there. We're going to come back to the ESSER 2, as I said, the 114. The administrative money, the first administrative money would have been very small. It would have been in the neighborhood of 130,000. The second, $632,000, that little 0.6 there. We haven't really worked with the administration on how they're spending it. And it's also, they may have some plans, but one of the things we're thinking about is that's enough money that you might be able to use some of that for helping with communities sort of figure out what to do with the money. We'll talk about that more later. It's a big enough number to notice. Then we get to the gear money.
Yeah, 1 second. I want
yeah.
Senator Perchlik to have an opportunity, please.
Sure.
Yeah, I had a question about the money that was set aside for the independent schools.
Yeah.
Is that just part of the 27 and the 114, or is that part of the 10%?
No, it's coming.
Nope,
It's
that's coming next. That's the gear money. We call that the Governor's Emergency Education Relief Fund, and right below it, you'll see EANS, Emergency Assistance for Non-Public Schools. So the gear money in the first CARES funding was $4.5 million. And what happened to that? It was all went to tech centers, and that was done earlier along. I think you were all part of it and talked about it, but I think it was done by AOE. Gear 2 is $2 million, has not been allocated yet. I know the administration is working on plans, and I'm sure, and you could be talking to the secretary about what their thinking is. The gear EANS money has to be, the way it works is the administration will set off an RFP. Private independent schools will apply for it. It's got to be COVID related. If they don't use it, it goes back into the sort of the gear 2 number of 2 million, and you'll have more money to give out to. So it's sort of like it's not a normal thing for the private schools to expect this money. Whether they use all 4.1 million is unclear. And I think that a lot of people think there'll be some of that back. Then you have a little bit of gears administration, $200,000, and that's just a little chunk there. So the thing about it is, if you spend money, you can spend the 2 million from ESSER 1, the 9.2 from ESSER 2, the 632,000 of administration is sort of on the table, the gear 2 money, the 2 million there, and there may be a few more dollars to pick up. So there's a lot of little sources here. Then we get to this big chunk, the 114.3. I just want to flag that. So if you think about it, that's going to go out to schools, again, once they apply. And it raises some interesting possibilities because it's not built in the 21 budget, essentially. It's not built in the 22 budget. One of the things about this money is this is all 1 or 2 year. I mean, this money goes through 2023, really. It's actually more like 2.5 years worth of resources. You don't have to spend it right away, but it's not forever money. It's not a base, so that you want to be a little careful when ESSER stands for Elementary and Secondary School Emergency Relief Fund. And it's on the top of the sheet. You'll see that little, Catherine had a little note of what everything stands for. So anyways, so the thing is, the money is available. One of the big concerns, and we're going to talk about this even as big, very concerned in a minute, is that it doesn't build. You have to be a little careful not to build ongoing needs. Unless you do, you'll be hit at some point with a budget growth that you will not have to have revenues to meet. You'll have to produce your own revenues and affect taxes. But the thing about the 114 is it goes out on a Title I distribution level. There is some thinking that what could happen, you have to give that out. That is definitely going out, being distributed. But if communities get that, it may be something where you could bring back some of the money you would have put out for state aid to education in the formula, and basically not the formula, I don't have the right word for it, but in this on the ed fund balance sheet, the amount of money we pay to schools, if you were to basically bring some of that back like we did a few years ago for healthcare, because they're getting this money, you can use it as an offset. And that gives you some capacity to fund other things using these sort of education dollars brought back. And, there's been a number of ideas. One is we're in the middle of a pandemic. We really don't know about the weighting, sort of the whole weighting thing that, do you take some of it and use it for a block grant for low income students? And what happens that way, there's no losers. You basically, everybody's getting the Title I money, and some people are getting less Title I money, but in exchange for that, they're getting, some people are getting more of, low income block grants. So there might be a way to do that. There might be money to provide for some of the school construction needs, or if we go ahead with the PCB money and they find stuff. Or, your committee has a lot of really innovative stuff being thought about in literacy and issues like that. It would give you sort of resources for that. You have little resources in the sense of everything is big, but the ESSER money gives you this 9.2 and the 2, but there is a chance that we take that 114 and offset the ed fund payments a little bit, and then that could produce a lot more money, which you could then allocate based on priorities of the committee. So that becomes another resource. So just, in the resources on this page, there's the amount of savings in the ed fund that we're going to see in the bottom line once we know what budgets are, which is the one we talked about first. Then we have these two little ESSER state agency pots, 2 million and 9.2. And then we have the possible use of the 114 to create an offset in the education fund. And then you see the little bit of gear money, and if anything comes back from the emergency assistance to non-public schools. So if this is confusing, it really is confusing. And there's just it's just a lot of choices. So part of what happens is, you're developing what your list is of important things to do. And then we just have to sort of match it up with where the money is. And that'll be probably discussion between you and appropriations. Just as before I leave this totally, there's two more things I just want to mention. One is that this is what we know about for sure, but we also know sort of that there's another bill in Washington, and that other bill in Washington is going to have 3 more pots or tranches or something of money that we have to keep an eye on, or maybe 4. One is there'll be some money directly for K-12 education, and we don't know how much, but it could be a fair amount. Could easily be that another 100 million or so coming to the schools, and we don't know what the conditions are or what it'll be. We also know that there'll be in the neighborhood of 650 million to the state government to allocate for lost revenues, things like that. And I don't know that that'll be used for education. It's a big number. It could be used for broadband, housing, pensions, you name it. But there'll be that big money. Then we've also been told the local governments, and local is a funny word because it includes schools, municipalities, CUDs, it includes regional planning entities, you name it, $300 million in Vermont. So, and that's a really new thing. I mean, to give locals money like that, and it's 300 million is not a small number for local governments in Vermont. And it's unclear whether, some place like Burlington and probably Montpelier and Waterbury and Rutland will have the administrative capacity to take that money and figure out what to do with it. A lot of places won't. And that's going to be something that, one of the things we need to talk to is VLCT, and just what is the sort of thinking now about how do we deal with that. But also a good chunk of that money could go to local education entities, could go to meeting needs. But we don't, as a state, we don't think we'll have the control of that. That'll be like something that will happen at the local level. What we could do, just to throw out ideas here, is you can probably take some of the state money and use it to match local. So that way you can sort of steer where that money goes. So something to think about. There's going to be a need to be creative because you're going to be, trying to help these communities navigate having more resources than they normally would. Then there's one more pot, which we don't know a lot about, which is there'll be another allocation for counties around the country. Now in California, counties do Medicaid and provide a lot of services. In Vermont, not so much. The counties are pretty non-existent. So most of the expenses are at the state level. But the language read coming out of the House or is reading in the House, that if the counties don't basically exist or don't have much administrative capacity, the money goes to the locals to be spent for people in the same proportion as there are populations of the county. So, and that's a little strange because all the services are provided at the state for the county. So there's a lot of, this is at the House level. We haven't seen the Senate version. So a lot of this is unknown, but the moral of the story is that if you have a lot of money on this sheet right now coming to schools, you have a lot more money that may be coming to schools and local government. And the capacity to use this money is going to be, it really raises the concern about the technical assistance needs. And, one other thing we've heard about, which you may know more than I know about this, when the bill passed in December, the relief bill, it was coupled to the federal fiscal year 21 budget. And the federal fiscal year 21 budget also had appropriations to schools and Title I, Title II, special ed, and a lot of other sources of money. And many of those had increases, and it may have been small, like $3 extra million for special ed in Vermont. But some of these monies had to be applied for. And already this is sort of taxing the capacity of schools because they don't, all this stuff coming in, being hit with having to manage the CRF money, then having to manage the 27 million. Now we have the 114 coming in. And then you also have all these other new monies. It's just a limit to what people can do. So one of the things we're sort of encouraging you to think about is just how do we build the capacity of the educational system to use this money, process it, and be effective with it. Because they're going to be on that same burden we are. Several, I want to say one-time money, but it's really maybe 2 or 3 time money, where you want to build strength for the long term. So this is a real big problem.
Say something about that. Would you, for example, how would one build capacity? Are you thinking, everybody might need an upgrade to their business managers? I mean, what sorts of things? Because you're right. These are dollars, and I know Ms. Benham has also said this. These are dollars that school districts aren't necessarily used to handling.
Yeah. So the answer is I don't know. I think about it. Do you give AOE a real capacity to do more technical assistance?
Yeah.
The other thing you could do, here are 3 proposals. One is the AOE. One is what the state is doing. There's a state hired guidehouse to help them with their management of CRF money. Now what they're doing, because, here's the other thing I forgot to mention. FEMA went from 75% reimbursement to 100% reimbursement. Well, a lot of the money that went to schools is FEMA eligible, 30 or 40 million. Yeah. And you could bring in Doug Farnham, who from the administration, to talk about that. FEMA is getting 0.5% payoff for every dollar they are able to run through the FEMA system. So they're helping by providing technical assistance. So one thing you could do with schools is, talk to FEMA, talk to the state about their consultant maybe working with schools to help use FEMA. But then you have to decide, if FEMA does turn money into a FEMA and you free up that CRF, who gets it? Does the schools get it? Does the state get it? Does it get divided? There's a lot of thinking that needs to go on. But yeah, so I would say the second thing is consultants like Guidehouse that are working with the state to help them. The third thing is, and this is the one that is sort of a wild card, if it's not AOE and it's not that type of consultant, do you go to the superintendents, the principal association, the LCT, and say, there really needs to be some group out there that can work on, work on this and provide them with the resource. And there really isn't anybody who's really thought this through. And so you may be it's just a big issue. And I think you probably could, if you had the time, you could talk to the education folk and see what they think. I don't think many of them have even begun to focus on this new federal money coming. We're going to see it'll feel much more real the end of next week when the House acts. And then what will happen is it'll likely occur in the middle of March or around then, because what happens is on March 15th, I think it is, or 14th, or somewhere in that area, the employment UI runs out, and people in Washington want to make sure that the new bill comes out in time to keep people on the unemployment rolls. The question is, do they, we've seen it before where they do, continuing resolution bills as they work things out. So it could get delayed beyond that, but it's not going to get delayed a lot past the middle of March. I think it'll happen. And then there'll be this incredible pressure to sort of figure out what we do with the money and how we get it out.
Questions? Senator Hooker, please.
That's a lot. And I'm just wondering, this money that's left, like $127 million, is that what we have now from the first tranche of money?
That's from the December 27th bill.
Okay, so that's what we have now. We're not even looking at the federal money coming in, but this money is money that we could look at and try to appropriate in this expedited.
Well, the 127 million actually goes right to, they have to apply for it to the state, but it has to go out to the schools in Title I allotment. So we have no control of that money. What you could do is you can make that heroic leap by saying, if you're getting this 127 million, you already have your budget built for next year, and you already have your COVID needs essentially handled by the 27 million you're getting the first time. We're going to make the assumption that not all of that's going to be needed for COVID. So we're going to reduce the amount of money we're putting through the state ed payments and basically harvest that money in the ed fund and then spend that. So,
Okay.
whether you do 40 million or 50 million or some number, it's a possibility. And that's what we're sort of thinking about.
That money would go back to the ed fund.
Correct. It would go to the ed fund, and then you have a lot of control over that because that's state dollars.
Okay. Okay, thank you.
Senator Persley.
And Mr. Klein, are there any restrictions on this money like the CRS as far as timing?
So from what I understand, the ESSER money is got a deadline of 2023, and I'm not sure what the month is in 2023, but that's, we're 2021, so it's a couple years. And then there are definitely 15 categories of use of the money, but the categories are really broad. I mean, one of them might be mental health expenses or, technology, or they're very broad categories. It's pretty hard to find something you couldn't cover. There'll be some questions, and the administration may raise. They're coming up with their own. That's the other thing I have to mention. I think you can talk to the secretary about it. From what I understand, they're developing their own plan for spending all this money, and they haven't released it yet. It's something that they're working on for maybe, and you'll get the secretary to talk about when, maybe March. The problem for the House is that by March they need to be on the road and out. So that doesn't really work for them. They probably will develop their own plan. And there is also the question about how much it should be. Usually what happens, the administration presents a plan and then you have a chance to sort of put your own stamp on it. The timing is not ideal because you're going to have a whole bunch of new money coming in. And so that's that. Yeah.
So, so I've heard the amount $200 million that the governor is looking at. Is this the same money?
No. What 200 million are you talking about?
I don't know. I mean, I've heard, the governor has designs on $200 million, and what do we have to say about it? And I'm not sure. I'm wondering where that's coming from. That I asked this yesterday, I think, when we were talking about money. Is this the same money that the governor is developing plans for?
Catherine, what do you think?
I don't know. It's a very interesting question because I'm not coming up with 200 exactly. And when you add this up, because
yeah, that's my first thought was we add everything on the sheet together, maybe you get close.
You get to 175 if you add up the whole sheet, but we know 15 has gone to HVAC and the 27.6 is already gone. So it's 200 million for schools. Is that for education specifically?
No, it was the total amount that came in December that then the Joint Fiscal Committee accepted as a grant, and the administration had a proposal for the use of those funds, and Joint Fiscal, in discussion with chairs of some committees, made a decision about some.
Well, maybe you're talking about the renter assistance money, which was 200 million.
Part of that is, yes.
That's a different world.
Exactly.
One of the
And some
actually
of
is really
that got shifted over to other areas.
One of the problems and one of the things that's really different between this and the original relief bill, and it's actually going to create lots of confusion. The other relief bill, we had one huge chunk of money called CRF and $1.25 billion. And we sort of took that money and divided up into lots of little pots. Here, the bill that came in December had lots of little pots, and it didn't give us one big chunk of money. So there was 200 million for renter assistance. There was the money went over for education. There was other money for healthcare, and they're all in their own designated balkanized source. So you're hearing about a lot of different things. We can't move it between them. They're in their own universe. What's interesting about the new bill is it'll be a mix because there is these big chunks coming to the state, a chunk coming to local, chunk coming to counties. Plus, there'll probably be money for higher ed, money for schools, and money for other things. So it'll be in a whole new iteration and complexity of cash.
And just so as ever, just for new senators also, what we are sending and what Jane has seen and Becca has seen from this committee in terms of a draft are, again, just general priorities and, some amounts. It's all there. I mean, I'd say it's a work in progress. In other words, it's going down the hall and there's no rubber stamp. They're going to go through a similar process, and we may find ourselves, already we're getting, which we'll talk about when Secretary French comes in, we might get additional questions, if you will. So Thanks for this. Thanks for these priorities. We're going to work to get them in the expedited budget. The fact that we haven't heard back from appropriations and they haven't seen these numbers makes me feel more comfortable now that they've seen them, that they're going to try to find a path for some of these things. I think, again, as it relates to after school, literacy and access to higher ed. So
I think they will.
But I have a feeling I wouldn't be surprised if eventually these numbers even go a little bit higher, given some of these dollars that might be coming in.
But I think one of the things appropriations is doing is they're saying, and Jane sort of says, Senator Kitchell says, that you really have to focus on what you have today. And so they're really going to try to get the one bill out, the expedited bill, and get that going. And all this stuff for the future is sort of like in the future, but it isn't that far in the future. So I wanted to make sure it was shared.
Yeah, no, this is very helpful. Any other questions at this point or final comments, or if the two of you have anything? I see Secretary French has arrived.
I think we're good.
Good, thank you.
Okay. Great. Thank you both very much for coming in. Yes. Secretary French, good to see you.
Good afternoon. How are you?
Good. How are you?
Not too bad.
So we just had an encouraging conversation with Joint Fiscal. And as you know, we are working on providing Senate appropriations with just some guidance. You and I have, and I know you've been part of these conversations with the committee around some of our priorities. We are looking, of course, for your general thoughts and feedback, but specifically, one of the items that we've talked about that we have not been able to, we really haven't talked about an amount or what the agency might need is related to, if you're looking at the letter, number 3. We talk about the Agency of Education working with school districts to, and your folks, and you've been in here a lot to talk about this already, those families that are missing. We've heard from people, and we're wondering, first of all, should we be allocating some money, what those dollars might look like. And then before that, there are questions of partnerships with the Department of Health on nutritious foods throughout the summer, and also educating parents about the signs of depression and suicide. And we do know that some dollars have come in, as I think your office made us aware of, through a suicide prevention grant. And I know appropriations is wondering how, what that intersection might look like. So those are a few things to think about. And of course, we just are looking for your general ideas and appreciate any feedback.
Well, thank you, Dan French, for the record, Secretary of Education. I thought your list was totally consistent with what we're seeing in terms of the work in front of school districts, what we're terming recovery. So there's nothing really there that was surprising to me. I think, the issue, as I've mentioned previously, I think we increasingly, the agency, have acknowledged in the last couple of days, we have to do more to educate members of the General Assembly and others about what are the federal dollars that are available, and particularly this program called ESSER, the Elementary Secondary Education Relief Fund, how that works. So that's something we're going to do. I think also there's a need for us to organize some sort of a collaborative conversation between the Joint Fiscal Office, legislature, the executive branch, business officials, superintendents, and so forth, so we can, I think, look at what is potentially a pretty significant strategic opportunity to use federal dollars to address some of our needs as a state. We are, I think, benefiting from the small state minimum allocations of the ESSER program. which, still are very much being directed towards places in the country that have not opened their schools at all. And there's a pretty large group of states that have been operating all along that are chafing a bit at the ESSER program and starting to say, it would be useful to have more flexibility at the state level, or be able to direct the use of those funds a little more strategically. So that's something we're stewing on over the weekend, and I'll get back to you next week on sort of convening a conversation on that, because I think I was just in a House committee, basically the same issue, talking about ESSER, and this was corrections and institutions. They're interested in construction aid, and we're talking about this opportunity. So it's I see the pieces of the puzzle coming together a bit, and I just sort of raised the flag that we need to have a conversation just to bring everyone up to speed about what's available. But everything on your list is totally consistent with what we envision to be the recovery process. And I'll just sort of recap that a little bit. I know Deputy Secretary Boucher was in talking on that, but we envision requiring school districts to have a recovery team and to do an assessment of their district's condition in 3 areas, one of which is sort of the mental health area. Another area is what we call re-engagement or truancy, which I'll speak more directly to in a minute. And the last one is academic success. So, the first thing is we see all those things as sort of being equal. Initially, there was a lot of national narrative in particular about the idea of learning loss, and that language is still out there. Many states, including Vermont, we were dissatisfied with the idea that this is just about sort of like on a 2-dimensional level. Oh, you missed so many hours of instruction. All we need to do is provide you with X number of hours and we'll be back on track. And it sort of ignores, I think, or doesn't do enough service to the fact that this is a deep-seated emotional, social issue, this pandemic, and we need to heal that, and we need to point our systems to contemplating that all 3 of these things are important. And I think our school districts, absent sort of that emphasis, would fall back on what they do best, which is the academic piece. Not to say they don't attend to the other 2, but we need to help them sort of do that sort of assessment. And I think we'll find that, there are differences at different grade levels for students in those 3 domains. We're seeing some of that in some of the academic testing that's going on. So, districts are configured differently. We just want to tend to those things. At the same time, we also want to position state government to help them do that. So part of the idea of getting coherence about what is recovery and positioning that work is so that the Agency of Education could start to organize itself to support districts in doing that work, and then bring in our partner agencies so districts don't experience sort of that. Sometimes from a district perspective, state government's a very frenetic beast. We're talking to this agency, that agency. We want to sort of have more of a coordinated effect on the other side, the firewall of state government for them. So, that idea of putting districts first in an assessment mode to figure out what's going on in their districts and giving them sort of the tools to do that. Us then convening groups of districts to say, what are you seeing? What are you seeing? Let's identify those patterns. Next step for them to actually build a plan about what to do about it. And then the third step, actually going into implementation. All with the idea that planning phase would conclude, let's say, before June 1, because one of the biggest tools in their inventory is the summer programming. So they would start to then, okay, here are our priorities. What are we going to do with our summer programming? And while that's going on, to have them also start to leverage their federal dollars accordingly, because they do have some discretionary spending coming down. It needs to be focused on their priorities, and they also have other funding that they historically always have, like Title I and so forth, that typically pays for things like summer school, and some of those funds can be used for things like child nutrition. So we want to position districts to go through a planning process, identify needs, help coordinate the state response, and then turn into the summer as the first opportunity to start to really do some implementation on recovery. What we don't want to have happen is to just wake up in the fall and start this work from scratch. We think it would be a huge missed opportunity, especially with Vermont's relatively positive conditions, to try to do more this spring is our goal, and particularly to leverage the summer. So that being said, truancy as an issue, what does that start to look like, that domain? Firstly, I'd say, if you're familiar with the current construct on truancy, School districts are supervisory unions are required to have a truancy policy that's based on a regional protocol in essentially their counties, that's worked out with the state's attorney in each county. That's sort of the construct. And there's usually something worked out where an affidavit is filed on the part of a school district ultimately that involves the state's attorney and ultimately law enforcement. That's going to be that whole construct is woefully inadequate for what we're looking at as a result of COVID. We have a backlog of truancy affidavits from the spring that haven't begun to be addressed. And honestly, the court system will tell you we've got more important things to do right now than that. So that's why we qualify this domain as being re-engagement as much as truancy. We think we need to be more proactive. So we are starting conversations with DCF in particular. We've been meeting with mental health pretty regularly since September. Just now starting to meet with DCF more regularly to orient them to this planning process and to how to figure out how to plug them in. Almost immediately, one of the first things we heard from them is a lack of resources. So we know there's going to be a need. Go back to ESSER, we have state set aside dollars, but there's also district level dollars. There's going to be a need to interject some funding into this sort of category of, I'll call youth services and family outreach. We have a different infrastructure with mental health, but I think right now we can say this is going to be, it's one of our three domains. It's an area where we're going to have to make an investment in some resources as part of the COVID relief. And we're getting poised to do that through our recovery work. So, just to back up and say, yeah, it's on your list, it's on our list too. Here's how we see that unfolding and being enacted on a regional basis.
So yeah, that's incredibly helpful, and I appreciate it, being on your radar. So Senate Appropriations is wondering really are there dollars that we should recommend that they might allocate to help with that work? And certainly, as we're advocating for, again, bringing students. I think the way you say it is perfectly, re-engaging students, re-engaging families. We're making an investment in summer programs, which will hopefully help to do those kinds of things. But, it was interesting when we heard from, I don't remember if a colleague remembers what principal we heard from, maybe Twin Valley, who is, spending time and money going out, and it's wonderful just checking in and seeing, and we're just wondering if the agency needs any specific dollars at this point to help facilitate that work or help facilitate some of the things that you're all doing.
Yeah, I think we do, but I think we also have those dollars in our state set aside, and that's where I think we need to have a strategic conversation just to educate everyone. And just to give you a sense of what that looks like. So we're largely talking about this ESSER program. Mm-hmm. And under ESSER, the state education agency can set aside up to 10% of the state's allocation for state level activities. We received $31 million in ESSER, what we call ESSER 1 last April, and we set aside $3 million, the maximum. We recently received $127 million as a state in December, early January for ESSER 2. We've set aside the maximum, that's $12 million. And what I saw this week and what shaping up to be ESSER 3 would be an additional $27 million, or $270 million coming into the state, but $27 million that the state education could set aside. So there's a considerable pot of money there that I would argue the General Assembly should have an interest in directing. Mm-hmm. But it's a finite, just like any pot of money, it's a finite pot of money. Sure. I think what I'm saying to you is here are like the three domains. We want to do a needs assessment at the district level so we can understand what the needs are. But we anticipate that the state level funding and spending will be in those three domains, and probably will be more heavily in the integrated social service area, like truancy outreach or supporting districts doing this work. And I use Twin Valley as an example. If you are familiar with that region, probably more so than some of the others, if you're not from Southern Vermont, it's a very federal school district down there. The school district itself is one thing, but it's in a supervisory union that really doesn't work together as a single system. They're very much standalone entities. Halifax, Reedsboro were the first people to come forward with a divorce under Act 46. I love those guys, but they've never really worked together, largely through their geography, which is very challenging. They never really worked together as a complete system. They're sort of new in that experience. So, one of the things we would like to see is, we certainly would like to leverage state dollars to go in and help them start to act more like a system. Because that organization often shows up on our list in other areas of they struggle with data reporting and so forth. So at any rate, getting some direction from the General Assembly on how to leverage those state set aside dollars. I think those are the only federal dollars in the game right now. So there's been a lot of talking about federal dollars. I think we're just talking about the ESSER set aside. It's a whole nother question as to what extent the General Assembly could be more proactive in directing how the locals spend the bulk of the funding, the 90% piece that they retain. That's questionable, but what we'd be seeking to do in the next week or so is to really educate everyone about what's involved and to convene almost like a steering committee about how to approach these strategic spending issues involving members of the General Assembly, members from the school district administration community, and also folks from the executive branch. Because I think we have a huge opportunity, and I think we can work together as Vermonters to collaborate on this pretty well.
Right. No, I think that's great, and I think it'll be great to be a part of those. As you know, Senator Probst is just looking again for. They definitely want to be directing. They want to, they want some specificity. They want to be giving guidelines, and so. We've given them some specificity, some direction around these things in terms of dollar amounts. What I'm hearing, and correct me if I'm wrong, is generally what you're saying we could say to them is, to just generally direct the Agency of Education to work with school districts, again, to work on this general re-engagement. And I think, honestly, if we don't put a dollar amount in right here, which is fine, we can generally, or Jane or Senator Kitchell may punt some of it back to us and say, hey, I need you to have Secretary French back in because I want to give a dollar amount, but or I want you guys to help guide us around a dollar amount. But you're saying right now, just generally saying, giving a Probst, the language to direct you guys and without putting a dollar amount in. Does that sound?
Yeah, I would just say, if you're talking about ESSER, in the state set aside, what I would seek to do in the next week, and your list is essentially the sort of idea of articulating out what are the strategic priorities, and you're putting specific I'll call them placeholder amounts.
Yeah.
But I don't know when you were drawing that list, if you were thinking about the state ESSER set aside and you knew conceptually how much was in that pot when you wwere drawing up that list.
So that's a great question. So the way it was directed to us is Probst will figure that out.
Yeah.
And they made that very clear, and that it will be what I think they're appreciating is, again, there are going to be multiple trains leaving the station on all these funds. So they're just kind of wanting to get a sense of again, priorities, placeholder amounts, that kind of thing. So
yeah, and I think it's fine to put placeholder amounts because I know the second part of the conversation is coming. I guess what I'm trying to message is that I'd welcome the opportunity, and I think we honestly in the executive branch have a responsibility to sort of convene that conversation because I think everyone has to have full visibility on this opportunity. I'll keep phrasing it as an opportunity.
Sure.
But I also know we have a lot of work in front of us. School districts have a lot of work in front of us. It's going to take several years. But I think, Vermont, as we've navigated other parts of the emergency, we can be very successful in this, but it's going to require us to look at the whole thing, not just the policy pieces separate from the money. I'd like to put the whole thing on the table and say, hey, what do we want to do?
No, but that sounds good. And it sounds actually that it works quite well with this letter in that, again, we will put some dollar amounts out there. We're putting some priorities out there. We know that people are going to continue to have the conversation, but at least Probst and others will know that these are the things that we're thinking about and that they're aligned with what you're all thinking about. It's great. Questions for Secretary French? Senator Lyons, please.
Thank you. And thank you, Secretary French. Sounds like we're beginning to move in the same direction, which is really very good. And I think for us, the greatest concern, of course, is children and their mental health, and then their ability to get back to a more normal school environment. So just first to express a concern, and that is, as we hear from the Department of Health, and my experience in particular with Department of Health is how very much they're engaged with some of the areas and policy direction that we're talking about. DCF less so. Of course, mental health, because they provide the expertise underlying it all. And as you're talking about truancy and working in that area, I think it's really important for us to remember that it's the mental health of the child that may very well underlie their truant behavior. So having mental health as a high priority seems appropriate, and part of that is getting kids back into a summer camp environment or whatever else is needed in the short term, the sort of the acute care that we're looking forward to. So those are really my comments, but I very much appreciate your comment on having policy direction, and I think that the committee has worked very hard on that. So I hope that we're synchronous. That's all. But thanks. Thank you.
Oh, thank you.
Great. Terrific. Any other final questions for Secretary French? Extremely helpful, Mr. Secretary. We really appreciate you being here, and I just want to thank you and commend your other colleagues who have been having conversations with us over the past couple of weeks. Thank you for that, and please thank them for their incredible professionalism and preparedness. They've been just terrific.
Oh, thank you. We look forward to the opportunity of working more closely with you in the coming weeks.
Great.
Appreciate it.
All right, thank you.
Take care.
So committee, before we move to looking at streamlining certifications and licensures for teachers, Senator Kitchell and Balint, again, are looking for this direction from us. I think what makes the most sense to me is we really keep our letter as is. We do plug in, I think, as a placeholder, if you will, some $500,000 to the Agency of Ed to look at the re-engagement and truancy issues. And just knowing that there is fluidity. I mean, there are going to be conversations down the hall. We may also get language back and additional questions. This isn't a law. Remember, these are just general guiding principles and things that kind of an update. And Senator Kitchell seems to want it terse. In fact, I think if we had 1 through 5 with a dollar amount next to each, I think it'd be fine. And remember, we'll also have to send some language out later on that might give some additional guidance in a bill. Any questions? Mr. Desmarais, do you have what you would need? We're just plugging in that additional dollar amount. Anything else? I think Senator Perkins sent along some language. Was that for this, for the after school, or was that for the literacy bill? I'm sorry, or was it?
It was for this.
It was for this. Okay. And has that been, do you have that?
I'll make both of those changes and then I'll get this over to you in final.
Thanks a million. And then we'll look at it right before we leave.
Yep.
Mr. Holliday.
Hello.
Welcome.
Thank you.
I don't think you've been in this year. However, someone with the same last name has. I don't know.
I know her well. Yeah. She was on the first floor when she did testimony. So.
Well, thanks for being with us. This is actually now shifting a little bit to conversations we've had around the possibility of, teacher shortages in the future, getting more teachers in Vermont, also taking stock in, what might be happening this summer in academic needs in the classroom next fall. And wanted to get a sense from you of licensure, teacher licensure, and what that looks like in terms of reciprocal relationships with other states. But also, one of the things we're looking at is to have a look at our certification programs for teachers, particularly around issues of or topics like literacy. And I'm not sure if you're the right person to address all of this, but those are some of the things that we have been talking about. Do we have a reciprocal relationship with the state of Maine? Could a Maine husband and wife who might be teaching over in Portland come over and teach here? Do we want that kind of thing? And then also, what do things look like if we were to move forward with an assessment of our teacher education programs? How might that assessment transpire? Would you be involved in it? Would the Agency of Education be involved in it? Again, looking at the issue of how are our teachers being trained to teach reading and writing. So with that, thanks for being with us, and the floor is yours.
Sure, I appreciate the opportunity always to come. This is my first time at Senate Ed this year, so it's good to be here. My name is Patrick Halliday. I'm the director of the Education Quality Division at the Agency of Education. So I'll start with a few comments around reciprocity. At any point, though, please feel free to interrupt me if you want some clarification. If it's something I'm going to talk about in more detail later, I'll just kind of say I'm going to get to that in more detail. But please don't hesitate to talk over me and to ask a question of clarification. I think the two big, maybe three big takeaways is there is an existing reciprocity agreement. It's through a group called NASDAQ, the National Association of State Directors of Teacher Education and Certification. So if you think NASDAQ is a mouthful, the whole word, acronym is even more so. But it's basically people who sit in my position across the different states and the state agencies of education. So they have what they call their interstate agreement. Vermont joined it fully in 2015. And this interstate agreement, I'll talk about in a little bit more, but really there are 47 states, DC, Guam, Department of Defense are all signatories to this. And while there's a lot that's left up to the individual state, in Vermont, if you're a signatory to this interstate agreement, more or less, I'm going to simplify, you have something that's pretty close to full reciprocity to come in. One of those I'll talk about in a bit more. One of the states that's not a signatory, unfortunately, is New York, and that brings up a few issues, what I'll get to later. I think the other thing around reciprocity is, regardless, if you have a teaching license somewhere in the United States, and any state issued teaching license, with a very, very few exceptions, at the least, you're going to be eligible for a 2-year provisional license, which would allow you 2 additional years teaching as a fully employed, fully compensated teacher to fill out, to complete a couple of potential other requirements that may be met. So those are kind of the two big things that to take away. To talk a little bit more about the NASDAQ agreement, as I mentioned, each jurisdiction, they use the word jurisdiction instead of state because of places like DC and Guam and Department of Ed. But each jurisdiction creates its own reciprocity rules. In Vermont, if you come from one of these states, if you have a license from one of these 47 states, and you want to come to Vermont, it's effectively processed as an initial license from anyone who maybe went through an ed prep program in Vermont. There's very, very, very little difference. You will be issued a license that's commensurate to the endorsement that you currently have and for the age range. So there may be a few differences based on state. For example, I know for years ago, I lived in Missouri, their elementary was 1st grade through 6th grade. If you came to Vermont, we don't have a 1st grade, we have a kindergarten through 6th grade, so you'd be given that K through 6, which is the commensurate license, sometimes some small differences in age ranges as well. We have a couple different levels of license, full licensure, level 1 and level 2. If you come in through reciprocity, everyone goes to a level 1 license, regardless of how many years you've been teaching. That doesn't have any impact on compensation, however. It's just the main difference is the regularity with which you need to renew your license. There's no additional testing required. So if you have to take the Praxis Core or the Praxis 2 for initial licensure, if you're coming from another one of these 47 states, you do not need to take any additional any testing. There are some jurisdictional requirements that Vermont puts in for a limited number of licenses, and those are around educational degree, experience, and certifications. For example, if you want to have an administrator certificate, you have to have a master's degree. There are some states in the country where you don't have to have a master's degree in order to have an administrative certificate. We would not grant that license if you for say a principal if you don't have a master's degree. Similarly, for a principal, you have to have 3 years of teaching experience. We would not grant that license without 3 years of teaching experience. So if I came from Indiana, I had never taught in the classroom, but I had an Indiana principal license, we would not directly grant that without those 3 years of teaching experience. And then certifications are things like, if I'm a health teacher, I have to have an up-to-date CPR certificate. And so those, you need to be able to show that you have those. And then just like with all applicants, fingerprints, attestations, just for safety. And those are for practicing teachers that I've been talking about, but it really works almost exactly the same for someone who's prepared in an ed preparation program, whether that's in one of these 47 states, whether that's University of Massachusetts at Amherst or University of Arizona. You're going to be granted, as long as it's from one of these 47 states and you're in an accredited program, we will view it largely as a Vermont program. Now, the challenges come with these 3 states who are non-signatories. Now, 2 of them we see, once every 5 years. Those are New Mexico and South Dakota. So we don't really worry about them because in practical situations, that doesn't happen too much. New York, though, is one state that has not signed it. And it's complicated from my understanding and talking to my colleagues in New York. It has to do with that the old agreement is written into law in New York, and changing that law is extremely complicated. The short, though, is that they have to apply through a completely different route, which we call transcript review. And so regardless, so an experienced teacher needs to pull up old transcripts and syllabi and show how he or she has met all of the different endorsement requirements, standards for the specific endorsement, be that math or elementary education or PE, as well as what we have our core teaching standards, which everyone has to meet. So that's a much bigger lift. Additionally, those teachers who are coming from another state, from New York, would also have to pass the Praxis Core or the Praxis 2 if that were required for their particular endorsement. And similarly, candidates from these 3 states, largely New York we're talking about though, if they were prepared at, say, SUNY Binghamton, they would also have to apply through this transcript review route as opposed to the typical initial route. We have, depending on the year, somewhere between 70 and 100 folks who are coming from New York. So it's not a huge number, but it's not an insignificant number as well. And the other thing I guess I'd just like to add is that that even in these cases where there are hoops that they need to jump through, those educators would still be eligible for a provisional license in almost all cases. There are a few cases because of differences in states, but in almost all cases they would still be eligible to come in, teach for 2 years into that provisional license they would have, and oftentimes they would be eligible even for a 3rd year of a provisional license. And then just a couple things there has just in the last, I'm going to say 4 months during lockdown time, doesn't make sense anymore, so I may be off by 3 months, I don't know. But over the course of the last 4 or 5 months, NASDAQ has started a conversation looking at what they're calling the Interstate Compact for Teacher License Mobility. And the Interstate Compact, the example that they use is a driver's license. So if I have a driver's license in Indiana and I'm driving through Wisconsin, I don't need to stop and get a new driver's license to get through Wisconsin. And creating something that would work very similar for teachers, so that you would immediately be applicable across state lines. As with the driver's license, my assumption would be that after a certain amount of time, you would have some sort of grace period to move to the state where you're actually practicing. NASDAQ has convened this conversation. It's in the early stages. Vermont is participating in those. I've sat in on these conversations. I'm not central to them, but I've sat in on these conversations. And they're saying that they're looking at 18 to 24 months to completion of this. That seems optimistic to me, but that would be great if something like that could come together in that amount of time. Before we would obviously, agree or sign anything, we'd need to see the details of it. And I think I'll stop there in terms of conversations about reciprocity. And if there are any questions, I'm happy to answer any of those. And I'm also happy to talk about the education preparation programs too.
Any questions? Senator Perslow.
I have an unrelated question that maybe you'll be able to answer, and that is about retired teachers.
Mm-hmm.
And if they need, what's the licensure requirement if a school wanted to bring them in to teach?
So we have a professional license. It's called a retired license. And the retired license, I'm going to get my details wrong here, so I would need to look up the specifics on it. Our licensing specialist would be able to go in more detail on that. But the retired license allows a teacher to come in and teach a certain percentage of time. I can't remember off the top of my head if it's 0.4 FTE or 0.2 FTE. I would need to look up exactly what that is. And that's so that you're not simultaneously drawing from your retirement and being compensated, as an employed teacher. And I forget off the top of my head exactly what that is. But we do have many teachers who maintain a retired license. The standards for retaining that license are a little bit less, I don't want to say onerous, that's the wrong word, a little bit less rigorous, simply because a retired teacher is not going to have the same easy access to professional learning that's being provided by a supervisory union as an in-service teacher.
So right now they could hire them for like to teach a course, but they couldn't hire them to be like a full-time teacher to fill a position for the year.
Right. It would be very easy. And I don't want to say it'd be very easy. It would be relatively straightforward in most cases for a retired teacher to return to a level 1 or a level 2 license. There would be some implications though with receiving their retirement, and
right.
And those are details that I really don't deal with. So yeah. I would get that.
We had testimony on that. I just wanted to know if there was a separate issue on licensing. So thank you.
Yeah, the retired license limits the percentage of time that you can teach in the classroom, but moving from the retired back to a level 2 is not something that's impossible, and it happens on occasion, or level 1.
Mr. Holliday, is there a way, if all of a sudden we had a real teacher shortage in this state, like we heard about, I think in Brooklyn or other parts of the United States, would it be the act of the legislature to sort of open the door more, open the door wider? I think what they did in Brooklyn was, started to just reach out to people who had bachelor's degrees and getting people in the classroom with some quick training, that sort of thing.
Yeah, I don't know. It would be hypothetical to see exactly how that would play out. So what I can say is that we provide a lot of flexibility right now, and particularly during COVID times, we provide a lot of flexibility for schools to hire as a teacher on a provisional license, as well as we have another level that's an emergency license, and this is really when someone is struggling to find a school is struggling to find a properly qualified folk, and that would be exactly what you're talking about. Someone who's has a bachelor's degree, doesn't have to be in the subject area, and could be hired for up to a year on that emergency license. For the emergency license, there are some limitations. No special education or school counselor, I believe. I could pull up the full list of it. Positions can be met by someone on an emergency license. So there are some qualifications, but in a real struggle, it's certainly something that can be done. We've even entertained some specific requests for teachers who are a course short of finishing their degree. They've met all of their courses, but maybe for their major that's outside of education, who will be graduating in the spring, can they be hired on a full-time position, and allowing a school to do that should they decide to do it. There are some issues that come up with local contracts that are outside of our purview, but we are pretty flexible with allowing those emergency licenses, especially right now. The bigger problem is there simply, for certain endorsement areas, simply aren't a lot of people who are retiring or who are applying, and that's really special education. The other one is our administrators are the spots where again and again and again we see shortages of applicants. And it's not that we are not flexible with allowing people to work under a temporary license. It's there aren't people who are applying in those situations.
Senator Lyons.
So the current proposal is to streamline the interstate compact for licensure so that it would be less, you said onerous, but I won't say that. But there will be fewer requirements for becoming licensed in multiple states. So now that I'm seeing you shake your head, yes, that's where we're headed. But so my question is this: is this going to be done? I'm thinking there must be a compact commission, a group of folks who make decisions about this. And would this be done by rule? Because you've written down trends and rule revisions. Is it done by rule by the compact, or will the states involved need to authorize those changes? So, which, it would seem to me if this is a significant change to the licensure process, so would states legislators, for us in particular, be engaged in that, or is that something that would simply be approved by the interstate compact folks?
Yeah. So I want to just clear that this is the proposal, the early discussion on that compact. I don't know what the final version of it's going to be. I don't know how many signatories there are going to be to do this. And honestly, without kind of talking with our legal counsel, I don't know what we're not at the point where we've talked through how we would move that from a proposed compact to something that's actually being adopted by Vermont. So I don't know that for sure. What I feel comfortable saying is the way that Vermont has entered into the interstate agreement, I think this compact would have very, very, very little impact on what we do. Let me use two examples for this. So Vermont, regardless of the state, provided it's a signatory to the interstate agreement, we're going to grant a license to someone, whether they're coming from Alabama or Montana or Massachusetts. In Massachusetts, however, if I am a teacher in Vermont and I've been teaching here in 20 years, even though Massachusetts is a signatory to that agreement, when I go to Massachusetts, there are some potential changes taking place right now, but the way it currently stands is I'm going to have to take a different series of tests and in order to get a Massachusetts license. So the individual jurisdiction sets the rules for how reciprocal those actual agreements are. Vermont's has made the decision to be pretty to be pretty flexible with those rules as a way to draw more people potentially to the state. So I don't think that an interstate compact is actually going to have a major impact in it in our practice. But to the heart of your question, whether that's requires legislative action, whether that's the rulemaking process through the Vermont Standards Board for professional educators who oversee the rules around licensure and educator preparation, if they're the ones who would be doing that, and then ICAR and LCAR and the like. I really don't know what the proper plan is. That's not something that we've pursued at this point. I will say that the interstate agreement was something that the Standards Board initiated, and it didn't go through the legislative process.
All right, should we shift then to the agency proposed to us in a bill that we've been working on to review teacher preparation programs to assess to what extent the programs prepare teacher candidates for, we're moving toward evidence-based literacy programs. We heard from a couple of teachers yesterday. We don't know what schools they came from. For all we know, they came from out of state, but having studied elementary education and they started their jobs, or they didn't feel upon graduation equipped and ready to teach reading and writing. So would this be something that you would all be involved in with this kind of assessment?
Depending on the exact nature of the law, certainly we're the ones. So we have within our division, excuse me, we have the ROPA process, which is a state-run accrediting process for teacher educator preparation programs. We have we do visits. They've gone remote, obviously, since for the course of the last year, but we do visits to ed prep programs for each of the different endorsement areas for which they seek approval to prepare students to prepare their students to be licensed in Vermont. The one exception to that is the University of Vermont. While we still collaborate with them and we go to that visit, their approval is officially through a national organization called CAPE, as opposed to the state organization, ROPA. So whatever the standards are, it's ROPA's responsibility to go in and kind of ask questions, look for documentation to see that those standards are being met. So if I have an elementary education, we have right here in my hand, we have lists and lists of standards for every single endorsement area. They go and say, show us the class that this particular standard is being taught in. We interview professors, we interview students, we look for documentation for all of these things. So if there were additional standards that were being required along the lines of literacy, that would be something that, as a part of the ROPA process, we would be checking to make sure that that each ed prep program were meeting those. I will say as well that most of the programs, I can't say this with 100% certainty without looking at all of them, for most of the programs and most of the endorsement areas, there are specific literacy courses that are required. So if I'm looking at secondary math, which there is a course around literacy in the discipline that is a required course to be taken there. The same with middle school science, obviously with elementary, and I think elementary has a 3-course sequence that most schools are teaching. Most ed prep programs are teaching at this point.
Would you mind sending us those?
The endorsements?
Yeah, if you would send a link to our committee assistant, Jeannie Lowell.
Absolutely.
And then she can forward them to all of us. It might be helpful just.
And those endorsements, just very, very briefly, that they are revised about every 5 years. We have around 50 different endorsement areas. The revision process is we look at whatever the national standards are. So, for example, if I'm secondary English, there's the National Council of Teachers of English who put together national standards. We use that as a starting point. We bring in practitioners to look at these and say what's good about them. Are there things that seem outdated? Are there things that are specific to Vermont? We make that committee then forwards a proposal to the Standards Board, who approves, votes it up, votes it down, and then it would go through the rulemaking process at that point. And it's actually included in our rules. And so all of those are renewed about every 5 years. This year and next year, we're focusing specifically on all of our special education endorsement areas.
So when you email that, if you would pull out for us what would be required of our Vermont colleges and universities for elementary education, what courses would be required around literacy specifically? Pull that out so that we know. I think we all
sure
sat up, and took notice yesterday when we had the two teachers. And again, we don't know where they're from, but graduating from whatever institution in the United States and not feeling as though they were equipped to teach reading and writing after an elementary school education degree. Anything you can provide us would be helpful.
Happy to do so. What I can show is what are the knowledge standards that are required. The way those knowledge standards are actually enacted really depends on the individual university or the individual program. So some may have, 5-course sequence. Some may have a 3-course sequence. And that's really what ROPA does, to say, show us how you're meeting these standards, where the courses or these are being met.
Okay.
But I can draw attention to that for certainly.
Thank you. Thank you. Appreciate you being with us. Sure, we'll have you back, but this was very helpful to get us started and get us thinking.
My pleasure. I'm happy to answer any questions you have at any point.
Great. Thanks, Mr. Holliday.
Right. Yeah, absolutely. Have a wonderful afternoon. Have a good weekend.
Thanks. Okay. Late in the afternoon on Friday. Let's see. Jim, were you able to make those changes?
I was, yep. And they should be hopefully posted.
Okay.
Jane, have you gotten them?
I got the one you sent before Senator Campion asked you to add that last line.
Okay, I sent you the final version. Can you find that, or should I send it to you again?
Yeah, I haven't gotten it.
You haven't got it. Okay.
Are we talking about the letter to Probst?
Yeah. Jeannie, you received it at, I think 3:59. Is that accurate?
That's right. That was before you asked him.
Oh, okay.
No.
No, that's it.
Oh, well, then it's posted.
Oh, wait, maybe it's not.
Or maybe it's there. We just can't tell it's the new one.
No, I posted it a while ago. It should be up.
It just had money in it. It's there.
I had asked just for a final line of just mentioning, I don't know if you saw that, Jim, just some kind of, and we can fiddle with it together as long as the committee's comfortable with us doing so, some final line of around, listen, we understand this is the start of a conversation. Please direct us going forward. Any testimony, you need us to take, any additional direction. We look forward to partnering with you. That kind of closing. That's the only thing I was thinking.
But as far as the re-engagement, the placeholder is there.
Yeah.
On the letter that's on.
Yeah.
Our page.
But the after-school language is not changed.
No, you're right. Good catch.
No, sorry, it has changed.
I'm looking at.
I'm looking at the one. Version 4. Yeah. So number 4 says.
Yeah.
For the after, that's what you want, right?
Yeah, mine says.
It says for the after school for all.
Oh, well, that's not what mine says. The one I just downloaded off of our website for today's testimony.
Is it supposed to be volume 4, V4?
Well, don't worry about the V, because I'm not sure if I updated it for that, but the one I sent Gene for posting had the 5,500,000 in number 3, and there were 4 million for the after school for all grants program.
Yeah.
Yeah.
Okay,
You
that's
see that in our first look?
Right?
Not what I see on the website.
Jeannie, would you email Senator everyone what Jim sent to you, just so we're all clear?
Refresh your page.
Yeah, I tried to do that.
I sometimes have to go
Jeannie,
right
are
out.
you there?
Yes, I'm doing it.
Great, thanks.
Oh, well, let's see here. Now this won't let me do it from here.
I'll do it.
No, it's okay. I'll do
No,
it.
I've got it right here. I'm going to just send it to Perchlik. Andrew here at
It's on our website. It's the one that's dated today. And it's before Senator Campion asked for the closing lines.
The letter wasn't on our website initially, so I had to go back to yesterday to see it. And now it's on our website.
Oh, yeah. You know what? I am looking at Thursdays.
Mhm.
Great. Great.
Uh-huh. Awesome.
But you aren't asking for the language, Senator Campion, right? So at the end.
Well, we can just after. I don't want to keep people too late. I just want to generally get a sense if everyone is comfortable with this. In that Jim and I would work on some closing line that would say just literally, thanks. We look forward to continuing to work with you. Please direct us as you move forward. Something like that. And then Jim, I just want to make sure the fonts and the numbers are all just kind of lined up, and we've got that taken care of also. On one copy I have, things are a little bit bigger, a few of the numbers.
Oh, okay.
But, it says 1, 2, 3, and then the number 4 is in a different font size. Committee questions for Jim? Anything else as it relates to this or other testimony that we took today? As a reminder, Tuesday we are having a joint hearing with Senate Finance and the waiting study, and then during the rest of the week we'll be returning to bills that we are nearing the finish line on, hopefully, and also possibly taking up, some new work. As we look at the school discipline, for example, I see Senator Rahm put in a new bill that also addresses that. I think we should either marry the two or at least have the conversation to have Senator Rahm and to talk about that. I don't know if we have raised, I know people have asked me about SROs. That's not something we're planning on taking up until after crossover. Let's see, I'm trying to think.
Mr. Chair, just on Tuesday at 2:00, and I know we're meeting jointly, but I have been invited to be on a panel.
Okay.
And I'm going to, it's not an internal Senate panel, it's a national panel. So,
great.
But it's Zoom, so I'm not flying anywhere. I'll be back.
I think Senator Terenzini also has a conference next week. He was supposed to fly somewhere, I believe, but to a state that's probably colder than Vermont right now, Texas, right?
Yeah, every year I have to go to Houston, Texas for a few days, and so now it's by Zoom. So I will miss a couple days next week. Should be able to make the Senate floor, and it doesn't start till 11 a.m. So I'll be in health and welfare for part of the morning. And I haven't heard anything about SROs, Senator Campion. I don't know what you were talking about there.
Minor topic, right? Great. Okay, then committee, Jim and I will just tidy this up, send a new copy down to Senator Kitchell and Senator Ballant, and then we'll get feedback and we'll continue working. But I feel like it's a solid start. I appreciate everybody's effort and time. I think we'll continue to make some advancements, and for the first time out, I think we did pretty well. So thank you. And unless there are final questions, I hope everybody has a good weekend. Great.
Likewise.
You as well.